So may I pray for listing of the matter tomorrow, my lord? Person is inside the jail, and without having any allegations. That is why, my lord, only
That
for
is okay, but we are told from the registry only not to fix any matters tomorrow. These 2 weeks, we have some problem. Anyway, we are listing it on maybe by,
Monday. It will automatically listed. No matter. My mention.
why automatically listed?
Because it was filed on 21st of July. Today is
May
24.
it be possible? May it be on Monday? Monday will be listed.
Monday, probably it will be listed.
Tomorrow, not possible at all.
Only for calling of the case diary. That's all.
But all I will take as that money. Okay, then tomorrow.
Yeah, please, sir. So it's a humble prayer for taking up a PA matter as an unlisted matter today, as because
Not possible.
Lordship,
65 matters are there.
he has a
Not
ring ceremony tomorrow.
not possible, not possible. Not at all possible. No.
May I please, Lordships, I would like to mention, my lord, item 3 of my lord's single bench of Honorable Justice, my lord, court number 9, my lord.
Item 3 of the court
Item
number
3
9.
of the court number 9, my lord. So on matter may be listed on my lord 29, my lord. 29th of 29. Today's
Justice Chaudhary is not available today, na?
my lord. Yes, my lord. That's why, my lord. So otherwise, matter may not be listed. That's why I am submitting, my lord. On 29, 20. Obliged, my lord.
May I please, Your Lordship?
Court, item 3 of court number 9.
Court number 9.
Much
This
obliged.
criminal petition has already been numbered, my lord, but it's not yet listed. May I pray, my lord, for listing tomorrow, my lord?
Not at all. Not at all possible.
It's already
Maybe on
numbered.
Thursday. Whatever, maybe on Thursday. Not before that.
My lord,
Maybe
that-
on Thursday, not before that, or not at
my
all
lord,
possible. We are not.
Wednesday, it may be, my lord, it's automatically coming on Monday, probably, my lord.
Okay, then you approach registry. Why don't you approach registry?
Then your
If the matter comes Monday, then it's okay. Very good. Very nice.
Monday, I'm having some difficulty, my lord. Maybe
You
it's on Wednesday, my lord.
made a request before the registry, then not Monday, and Tuesday, Wednesday, it will automatically come. Otherwise, if you mention you're going to, we will be listing it on Thursday only.
My
Not
lord, it
before
may
that.
be on off, my lord, on
Not
Wednesday,
before that, Thursday. Yes.
May I please, Your Lordship. My lord, one criminal revision petition pertaining to Honorable Justice M. Chaudhary Bench, Lordship.
Whether it was listed today, no.
Not listed, Lordship. I am paying for listing in the next week, Lordship.
Now, see, from registry, though, maybe from the case of Justice Chaudhary, but the question is that we are having some problem, in fact, with these 2 weeks.
Under NI Act, Lordship.
No,
I have
whatever.
to pay 20% of the awarded amount.
Yes, I know.
Lordship, I will pay that.
क्या कोई नहीं पापा ये 2 weeks. No,
Next week, any date, Lordship.
mentioning. You want any specific date for mentioning? Otherwise, 1 week.
Any date next week, Lordship. Any date. Next week, any date, Lordship.
31st.
Deeply obliged. May I please, Lordship. I beg to mention item number 51. CD is not available.
50.
51. I'm on entry. 51 CD not received.
51. You are on entry.
Yes, sir.
CD not received. Issue reminder. Yes, Botapu, when can be?
On my lord, 27th of August.
27/8. Interim be extended till next date of listing. Okay.
May I please, Lordship? I beg to mention for listing of bail hearing, Lordship. Matter was listed last week, Lordship, but due to shortage of time, it was
Maybe
not
on
listed.
Thursday, not before that.
Lordship,
Friday,
can it be
no
on
comment.
Wednesday, Lordship?
No, sorry.
May I please, Lordship? I beg to mention bail application number 222-625. It was last listed on 22/7/25. But due to typographical error, no title page, it was sought to be corrected.
Maybe on Thursday.
Yes, much obliged, Lordship.
Please, Your Lordship, with regard to item 53, 54, CD is not received. We are on interim
50.
and 54.
53, 54.
Just let us check.
53, 54, my lord, CD not received.
In the both the matters you are appearing?
Yes, they are of the same.
Well, search sheet submitted in item number 53, my lord.
Oh,
53, 54, same already search sheet submitted.
charge is submitted. Your interim will be extended up to 15 days. Charge sheet has already been submitted. You appear before the trial court below for regular bail. Your AB will not be here now.
Okay. Lordship, if not, my senior. If
No, this is the order only.
Okay,
We cannot pass any other kind of order. What's your good name?
Tinlong on behalf of Didas.
Nam Appearing on behalf of Mr. D. Das. Learning council, same order hobo duita. So and so. CD not received, however, it is submitted by Mr. Botapu. That case has already been charge sheeted by both these CS number same,
CS number 40/25 dated
40/25,
dated 21/7/25.
both the matters, same,
Both the matter.
same hobo duita. আৰু আপুনি 15 days লৈকে extend কৰি দিব. Your interim, you were on interim, na?
Ship,
In
I-
both the matters, you were on interim.
Yes,
Yes, yes.
So your interim will be extended up to 15 days.
Lordship, but just now I have instruction that let my senior, he wants to appear, let the matter reach, not to mention.
So why you are mentioning?
Yes.
Why you are mentioning them?
I'm sorry.
From when you have got the instructions? You were here only.
Yes, I was here.
So who gave you instructions?
My senior just.
No, who gave you instruction at this moment? You're not attending any phone call also. I have not seen you.
Ma'am, I have just got an SMS, that's why.
Huh?
SMS message.
Though if it is a SMS message, then why you're appearing? Why you're trying to mention that case?
Lordship, I'm sorry, let the matter reach. Lordship.
The order, same order, dispose of it. They disposed of the matters. Let him appear.
Lordship, I beg to mention item number 5050, Lordship. Can the matter be taken up any other day, Lordship? It's on the person difficulty, 50.
Here also CD receipt.
Yes, CD received, madam, petitioner is in interim, otherwise the statement of the petitioner is not available in the case. CD, I will have to get the statement of the,
So updated one will be required.
yes.
Lordship, my instruction was we did appear, so let the updated case diary be called. Lordship.
50 due, CD receipt, but it is submitted by Mr. Bothapur that CD is not updated. To the petitioners are on interim. CD be returned, calling updated case diary. List the matter accordingly, yes, Bothapur.
On my
Right.
lord, 21/8, madam.
21/8. Till an interim be extended till next date of listing.
DP applied.
Yes, Lordship, for listing of criminal evidence, why I am convicted under NI Act, Lordship. Any date, Lordship, next week?
This was pertains to the Court of Justice Chaudhary.
No, Lordship.
Justice
New
Mani
new
Chaudhary.
case, Lordship.
Huh?
New case for listing, Lordship.
We are taking only the urgent matters of this
Lordship,
Justice
actually,
Mani Chaudhary's case.
I am convicted for 5 months, Lordship.
No, we are taking just urgent matter for this Justice Chaudhary. You may approach the registry in that case.
Okay.
May I please, your lordship. My lord, I bring for listing of a criminal petition, my lord. Next week, my lord, any day.
What kind of petition?
My lord, criminal petition, my lord. Criminal petition,
For quashing and all.
for quashing or order. of a-
Pertaining to the court of this
Session
Justice
judge.
Mani Chaudhary.
My lord, my lord.
Huh?
My lord.
Justice Mani Chaudhary.
My lord, my lord.
Is there any urgency? Except the urgent matter, we are not.
Urgency, my lord, my.
Okay, then you approach registry, make a date listing there. Please.
Okay.
Yeah, please, Lordship, I beg to mention for one criminal petition for motion, Lordship. On Tuesday, Lordship, matter is fixed before trial court, Lordship. Kindly list them
We don't
down.
have any alternative. It is a case of this Justice Chaudhary or what?
Lordship, new case, Lordship.
Make a request before the registry only. We don't have any alternative.
May I please, Your Lordship? I beg to mention item number 45. CD may be not available, Lordship. 45.
45. Not interim.
Are you on interim there?
Yes.
CD not received, issue reminder, interim be extended till next date of listing. List accordingly, yes.
1st of September,
19. 19/2020. Okay.
May I please, your lordship? Also, I beg to mention item number 34, lordship. There will be some difficulties, lordship. Kindly adjourn the matter.
34.
Yes, lord.
We don't know. Let us see this CD. Huh? We have received the CD here. Are you on interim here?
34, my lord. Start sheet submitted. my lord.
CS submitted already. We are going to dispose the matter.
Lordship, one more.
Your interim will be extended for 15 days. You are on interim, so that interim will be extended till 15 days. And otherwise, matter will be disposed of. Okay. You are MS?
SUT.
S?
SUT. SUT. SUT.
SUP.
SUT.
Acha, suit, SUT.
Yes.
And Agor Nam Sam?
Behalf of T. Som, Lordship, SUT.
S suit, acha, hard MS S suit appearing on behalf of MST Som, the learned counsel for the petitioner. Case was fixed for case diary, but it is submitted by Mr. Botap, the learned additional BP. That case has already been charge sheeted by, yes, CS number
31/25
31/25,
dated 31/3/25.
31/3/25.
One more pair, Lordship. Lordship, I beg to mention for.
Just a
listing-
second, 33/2025. In view of the filing of the charge sheet, the petitioner is hereby directed to appear before the learned trial court below with a regular application for bail, which may be considered in accordance with law. And till 15 days from the date of order, the interim order granted to the present petitioner will be extended. Okay. Yes, another prayer.
Lordship, I beg to mention for listing two criminal petition. Many time we
Thursday.
approach to the.
Thursday.
Lordship.
May I please, Your Lordship? Regarding item number 4 of court number 9, my lord.
Item number 4 of court number 9.
9. Kindly it may be listed on Monday, my lord. Because trial court.
They,
My lord.
I don't know, because
Because
though
there
it is a
urgency-
case of
there is
maybe urgency, but I'm saying repeatedly, I'm saying because we have some
The trial court date is this 1st August.
meetings around. Mr. Chaudhary is also interested with various in the event or call. Justice Chaudhary also interested with similar works. Monday, I cannot say. Anyway, let it be on Tuesday then.
Yes, Tuesday. Oh, let's.
Item number, you're saying
Item number 4, court number 9.
Item number 4, court number 9. What is the urgency in fact?
Trial court fixed on date 1st August, my lord. Question the petition, my lord. Question petition.
Okay,
Oh, let's.
May I please, Your Lordship, the item number 61, Lordship.
61 of this court.
Yes, Lordship. Supplementary, Lordship, the matter was already fixed on 28, Lordship, for bail hearing, but the said matter is take with the item number 60, Lordship, the motion gulo. Other advocate are take, Lordship, our matter, Lordship. 28 তারিখ 28 তারিখ fixed আছে মানে 61 is already 28 fixed,
But
Lordship.
it is along with 60 only.
No, no.
Simply fix it on 28.
28, Lordship. The bail hearing.
Only 60 or 61?
61, only, 61, Lordship.
But 60 is also along with 61.
Other engaged counsel.
So, both the matters or what to do?
Same case diary in both. the cases.
Yes. Yeah, CD has already been received also, I think.
Yes, sir.
Then
Already city received, Lordship, fixed on 28, Lordship.
then-
my matter.
then
Both the
you
matters.
Fix both the cases.
Mr. J. A. Ahmed is appearing.
Yes.
Then you will see, let the matter may be reached.
Let the matter may be reached. No, we have, it will be called for the letter may be reached.
May it please your lordship. May it please your lordship. My lord, I beg to mention item number 5, motion matter before court number 9. If your lordship.
Item number 5.
Court number 9, my lord. If your
Is there any
lordship-
urgency, but just tell us.
Urgency is there, my lord.
Why? What is the urgency?
So may
What
it
is
be
the
kindly
urgency?
taken today, my lord.
What is the urgency?
Urgency, my lord, here are the proceeding the domestic violence. against
Yes,
us.
domestic violence is there.
There are orders against us for this thing that.
Very nice. The order is there. That's why you have come. So no urgency.
May it be
Maybe
taken
on 30.
tomorrow, my lord.
No, tomorrow. He is not available. I don't know whether he will be joining tomorrow or not. How can we fix the matter? At best on 30.
On Monday, my lord.
30.
Your Lordship, I beg to mention item number 35. Senior is out of town. Kindly pass over the matter for the day.
Yes, what is the position of 35?
Item number 35.
CD receipt? Now just, he got an information from our registry that all the AB matters are lots of AB matters have been fixed. No, so we don't want to fix any date here.
Yes.
But you have received this case diary here.
Yes, yes.
That is the problem, no? At the request made 35, the request made by the London Council for the petitioner. List the matter accordingly.
My lord.
Are you on interim there?
No, no Lordship.
You were not on interim. But this 2 week, we don't have time.
Yes.
Then maybe on 12, 13 or whatever. 13?
Yes.
13/8.
My lord.
CD, can you retain the CD up to 13/8? Will be able to. If it is not possible, then it can be returned.
I will return the case. There is any step.
Returning to, it may not reach also again. That is the thing.
Very anticipated will.
Ah,
No, Lordship, may simply adjourn it, my lord, if my lord, police can again hand it over to us. We'll talk with them. Your lordship may simply adjourn it, then.
list accordingly.
Yes.
At a request made by so and so, matter is adjourned, list accordingly. As on a date to be fixed by the registrar.
I have some, it is for beginning the interim order. Entire proceeding of NIS has been installed.
In the case of what is to court number 9,
Code number 9.
yes, item number,
I don't know, it is.
where is the urgency?
As I, my lord, entire proceeding has been installed, NI proceeding, NI Act proceeding, my lord.
Already state
Already listed, I filed petition long back. And
for
also
vacation of state.
Vacation, my lord.
It's
Two
not
times
so
I have
urgent.
mentioned also that also not listed.
Not so urgent, I don't think. Not so urgent. You can, in that case, you can make a mention before registry only. It's not so urgent.
I make a register, I file a petition on Monday before the registry, but till today not listed, my lord. And
Okay.
earlier to that, I also mentioned before the court, also court allowed to list it, but not listed.
Okay,
Then
then
thereafter I make.
3030.
30.
30, yes.
My lord, item number 10. and
Today's
for-
list.
Yes, and 44 of the code number 9. This matter-
Item number 10 of court number 9.
9.
Side
And-
over item number 10.
And
of-
44. And
Item number 10 of court number 9.
and
Yes,
supply 44, maybe 10.
Suzanne,
Motion matter. Oh, Logan.
কি করছে?
Item 10 and item 44 of the code number 9,
Ah.
maybe taken up.
No, no, not at all possible. We are dealing with 66, 67 matters. No problem.
Then my lord on that.
30, not many matters have been fixed. No? He is unavailable.
It will listed
Okay.
according to the.
Okay, then 30.
Please, your lordship, on 17 CD was available, but matter did not reach. May come up next week, on Wednesday or Thursday, your lordship.
Which item is it?
Anticipatory bail on 17th, it was item number 34, your lordship. 17th of July, matter did not reach, CD
Ah.
was available, may come up on.
AB?
AB it is there.
No, AB are not going to list any AB. You make a mention before registry only. Not going to list. Okay.
May please, for listing of a criminal appeal along with an IA lordship, that will be fixed on 29th of this month, your lordship.
It was fixed.
No, your lordship. Matter be fixed, kindly be listed on 29th of this month, your lordship, for listing.
Not at all. Maybe on 5th of
5th of August.
5th of August.
May I please, your lordship, with regard to item number 41, your lordship will be pleased to take up this matter at 2, lordship.
41.
41
Okay, we'll see to it. At 2.
at 2 p.m. lordship. Much obliged.
CD not received.
CD received or not received? Yeah. Received. Okay. Okay.
Lordship, I beg to mention item number 33, Lordship. Lordship, CD is not available, Lordship. 33. 33.
33, my lord, CD not received.
I am on interim, Lordship.
You are on interim.
Lordship.
CD not received. Issue reminder. List the matter.
On 1st of September.
1st of September. 1/9/2025. Interim be extended till next date of listing.
May I please, I beg to mention for item number 44, CD has not been received. Interim order is there. It may be extended.
29 million.
29.
29.
Issue reminder. CD not received. Issue reminder list on 2/9/2025. Interim be extended till next date of listing. Okay.
My lordship, bring the listing of an II for rectification of your lordship, one of the orders, lordship, finally tomorrow, lordship.
Not tomorrow.
Lordship, no, what has happened is, accused was asked to appear before the jurisdictional police station by 29th, so it's not.
Okay,
rectified.
okay then tomorrow.
Okay, lordship.
Maybe lordship. Lordship, I beg to mention item number 52 of today's list, lordship. On last occasion, CD was called for, perhaps it has not been received, lordship. So there is interim and continuous.
I just want to check.
52, my lord, charge sheet submitted.
CS submitted. You are on interim.
Yes,
You are Mr.
R. Islam.
Heard Mr. R. Islam, the learned counsel for the petitioner. I also heard Mr. P. Waterpool, the learned additional PP appearing on behalf of state respondent. It is submitted by Mr. Waterpool that Case has already been charge sheeted by CS number, yes.
77/25
77/25,
dated 36/25.
36/20. বাকিখিনি লিখি দিব। Your interim will be extended for 15 days. Within that period, you may appear before the learned trial court below with a regular application for bail.
Maybe this lordship, I have to mention, I don't know, 43, maybe I don't.
43?
CD is received, lordship. The senior is out of station, lordship.
43 CD received.
Next week, another lordship.
You are on interim?
Yes, lordship.
You are on interim. Let CDB return because next week both dogs are pending. That the request made by the learned counsel for the petitioner. Case is adjourned. It is submitted by Mr. Botaku that the CD received. CD may be returned back with the direction to get the to send the updated case diary. List the matter, yes, give a longer date. 3/9. List accordingly on 3/9/2025. Interim be extended till next date of listing. Okay.
I have to mention item number 59, lordship.
Today's list.
Hearing metal lordship. Please the meter taken up next week, lordship. And lordship, the actually listed the meter IA, lordship. IA for lordship, the suspension of sentence.
No, it is a hearing column only.
Yes, lordship.
Earlier it may be the position that the IA may be final hearing for the matter was fixed for final hearing, I think. So I will not be heard. At present.
Next week, any date, lordship.
Hearing next week, though, I don't know.
2024 matter.
Pardon?
2024 matter.
Yes, 2024 matter. These are set August to piece of subsequent Thursday, but Tuesday at Tuesday or Thursday. Matter hearing matter, no? Tuesday again. Is it Tuesday? 7th video. 7th of August. And the request made by so and so, the matter on 7th of August in hearing call.
Iketas.
Iketas, okay. Hard Mr. Iketas.
May I, Lordship, with respect to item number 20 at the Lordship, I have instructed 20 at your Lordship.
28.
Yes, Your Lordship. I have instructed to withdraw the matter, Your Lordship.
28 minute short sheet submitted. Item number 28.
CS submitted now.
This letter may kindly be kept as a part of the record.
You are MS?
L. Wangsa, Your Lordship.
L?
L. Wangsa.
Her MS L. Wangsa, the learned counsel for the petitioner. You are appearing for T. Deuri. Appearing on behalf of Mr. T. Deuri, the learned counsel for the petitioner. Also heard Mr. P. Waterpool, the learned additional PP, appearing on behalf of state respondent. It is submitted by MS Langswa that as per instructions of a client, she wants to withdraw the same. However, Mr. Botakur, the learned additional PP, submitted that case has already been charge sheeted. Hide CS number. Yes, it will be okay.
That may be kept as a part of the record.
Yes, hide.
Case number 65/25. dated
65/25 dated 30/06/2025. 25. In view of this, the present petition is accordingly disposed of on withdrawal, and the copy of the challan be kept, maybe a part of the record. And record of the right.
Obliged, Your Lordship.
Maybe the lordship. I have to mention item number 47. As per petitioner instruction, we want to withdraw all this matter.
47, you want to withdraw this one? What is the instruction here, Terry? No, it is whether we have received the case diary here, no?
No, well.
You want to withdraw this one?
Yes, lordship.
You are a Mr.
Yes, Hussein.
S. Hussain. Heard Mr. S. Hussain, the learned counsel for so and so. And also heard Mr. P. Waterpool, the learned additional PP so and so. It is submitted by Mr. Hussain that as per the instructions of his client, he wants to withdraw the same. In view of the prayer is accordingly allowed, the matter is accordingly disposed of on withdrawal. Okay.
May it please your lordship. Your lordship, I beg to mention a criminal petition to be listed for withdrawal.
From court number
Court number 9.
9. Maybe on Tuesday, 29.
A release motion, AV, PA, item number 1.
কি ABB কোনটো আছে? AB টো 1 নম্বৰ কৰি থৈছে দাও। কি কৰিলে বা? এটা 1 নম্বৰ থৈ দিব নেকি? কি কৰিব?
Yes, already completed.
এইটো পিছত মাতিব আপুনি। বুজা নাই কি কৈছে? অ মাতি দিছে। ABB পইণ্টছ লাগিল এইকাৰণে। পিছত হ'ব। অ তো। Yes.
Lordship, I think wrongly listed as item number 1. Yeah.
Yes. Anyway, we are going to hear.
My
It
lord,
should be
this
after
is,
we.
this is very unfortunate case, my lord. What happened? On my lord, 14th of March, in absence of the owner of the house, theft committed in that house. Thereafter, lordship, on 15th, next day, when the owner returned, thereafter an FIR has been filed. After the filing of the FIR, after 3 months, on 16th of June, main accused persons has been arrested. 2 persons has been arrested whose names are Mohibul Hussain and Sofikul Ali. It is in the forwarding report. On the basis of their statement, lordship, what happened? They told that the thieves sold that property to one Mr. Javed Ali, and Javed Ali is also arrested, and all the stolen property recovered from Javed Ali. Now, lordship, this petitioner AB, she is the wife of that Javed Ali. Lordship, my humble prayer is that as the forwarding report is very much clear, which is at page number 16, all the stolen property recovered from Javed Ali. Now, lordship, I'm being the wife of Javed Ali. I may be protected, case diary may be called for, and Javed Ali also apply in item number 9. He is also applying BA. 39 days he is behind the bar, lordship. Her husband is behind the bar for 39 days. Item number 9. Now, lordship, my humble prayer is that as the stolen property recovered from her husband, he is already behind the bar, and forwarding report is also clear that all the stolen property recovered. My humble prayer is that I may be protected, CD may be called for, and lordship, if anything found in the CD, my interim may be rejected at that time. Lordship, this is my humble prayer.
Yes, Potter.
Yeah, otherwise, although name of the petitioner is not there in the, my lord, FIR, my lord, those stolen.
In the FIR, there is
From the possession of
nobody's
the
name.
accused Javed Ali. How she is involved, only case diary will involve, otherwise, my lord, those.
Yes,
stolen
I'm
items,
saying that.
list of any short date may be fixed regarding this.
I'm also saying that if she is involved, it will reflect in the CD. After coming of the CD, my entry may be rejected, lordship. That's all.
Otherwise-
Because, lordship, a forwarding report, prima facie, in the forwarding report, it is very much clear that everything recovered, and custodial interrogation is required where there is to be recovered something. But in this case, everything recovered, lordship.
Yes, Potter.
So, my lord, I may be protected. At least wife may be protected, and CD may be called for.
Otherwise, whether everything has been recovered, my lord, or not, my lord.
That we cannot say at this stage.
Yes, ma'am.
Some recovery is there, obviously.
Well, my lord, maybe, my lord.
If not recovered all.
Yes.
Column number
Anyway,
3.
let her be, we are fixing this. 9 is also same, na?
9 is also same husband.
Husband, so
39
we are
days he is
calling for a
behind the-
case that in body matter, she may be given a chance for.
Yes, lordship.
Had Mr. G. Sumwa, the learned counsel for the petitioner, and also had Mr. P. Waterford, the learned additional PP, and then state respondent. And this is an application under section so and so in connection with so and so. Considering the submission made by the learned counsel for the petitioner and the learned additional PP. I find it effective to extend the privilege of interim pre-arrest to the present petition till receipt of the case diary. Here, one date can be provided, for Thakur.
Yes.
Both 1 for 1 and 9. 9 is in custody, I think.
39 days lordship. So 2 weeks might time may be because 60 days offense, already 39 days he's behind the bar lordship.
Sixth of August.
6th of
Oblige.
Act number 2, 6th of August. 9 number 2, CD call for 6th of August. Beginning likhona lagi. Both the matters were listing on the 6th of August.
And lots of interim maybe
One interim is there on act number, I mean AB.
oblige, deeply
Should be
oblige.
under interim, asked her to appear before the DI within 7 days and.
Within 7
cooperate.
days.
Yes.
Oblige, deeply oblige, my lord.
Back, please, Your Lordship. What arrest bill, Lordship, what happened, Lordship, that there is a member of the Bazaar Committee, Lordship. The allegation is that they have taken the exorbitant money, Lordship, then the prescribed money. This is the case, Lordship, and the informant is the outsider, Lordship, he is not related to the any vendor or any the marketplace, Lordship.
So why he lost the FIR?
Lordship, self-interest is there, maybe a hike of the, for that exorbitant rate, Lordship, the rate of the vegetables and all has been increased, Lordship, maybe concerned citizen, Lordship, that I'm not to that point, Lordship. Only thing is that 17 days behind the bar, Lordship, and now in the meantime, as they were arrested, earlier committee was dissolved and new committee has been formed to take the Lordship that.
These petitioners, only petitioners were on the earlier committee.
Earlier committee, they are already arrested, local person, 17 days, Lordship, it is a admitted fact, Lordship, we have taken some exorbitant amount, Lordship, and that is our, for that we are behind the bar, Lordship. Further custodial detention will be required or not 17 days, Lordship. It is
Yes.
admitted fact, Lordship. I am not denying to that fact. Lordship. We have taken, we have got the, this one, Lordship. We have already behind the bar. Our committee also dissolved, Lordship.
Yes, bottom.
Kindly last paragraph, page 11, when I and my staff stopped them, then they attacked us with sharp weapon and tried to take away the service rifles of LNK Ranjan Guru,
Oh.
resulting. So these are lots of other, and before
Okay,
that,
we call for a
lots
case
of
diary.
other. allegations have been-
17 days already there, Lordship, the local person, Lordship, police also know us, Lordship. That is,
Okay, when it can be called for case diary? Facing shortage of days, in fact. Anyways, tell us because they are in custody. 6/8.
Can it be a little bit earlier?
30
Otherwise, nothing to go to the case diary, Lordship. It is admitted fact, we
1/8.
taken exorbitant money, Lordship. Now only our detention will count,
1/8.
Lordship.
1/8.
Much
One.
obliged, Your Lordship. Much
CDB call for 1/8.
Item free.
May I please, Your Lordship?
Yes.
So in this case, Lordship, similar matter is pending 31st July, Lordship. 37, 30,
After
31.
same FIR?
Same affairs, co-abuse matter, Lordship.
Okay, what date is pending on 31st?
31st of July.
July.
Already fixed for later. Kolkata
CDB
City.
call for fix on 31st. Okay, we're listing it on 30. We're listing it on 31st.
Item 4.
Wait, please, Your Lordship. Lordship, this is a regular bail application, Lordship. This present petitioner is a Lordship Secretary of a Assam Jatiyavadi Ghosh Chhatra Parishad, Laluk Region Committee, Lordship. Kindly, before Lordship peruse the FIR, kindly come to the page 20, Lordship. That is, the committee has clarified, Lordship, 7,000 was given to this Secretary, Lordship, to arrange Lordship, there is a flood, Lordship, and property, some students who had Lordship suffered, Lordship. They are decided to provide them, Lordship, school bag. That's why, Lordship, they have collected money, and that 7,000 is from the collection of the student, Lordship. Now, Lordship, kindly come to the FIR that is on page 14, Lordship. Now, Lordship, what happened? This petitioner, informant, Lordship, he is a businessman, Lordship, he is doing poultry business, Lordship. When he was requested to give donate something, Lordship, he has brought an allegation that he has given this amount 7,500 snatched away from him, Lordship, and demanded 5 kg boiler chicken, thereafter 3 to 4 boiler chicken, Lordship. Absolutely false and concocted case, Lordship, because they are Lordship sole motive
Yeah,
Yes,
we
to Lordship.
have fixed
Your
the
Lordship,
matter.
I think, on 1/8, madam.
It
Some
was
other
fixed
case-
earlier.
yes.
The other accused petitioners also appeared, so we fixing it on 1/8. Only matters.
Considering length of detention, because lordship, this is the case, lordship, just to damage the reputation of this person, lordship. Because
One.
they are doing for a social work, lordship, they are arranging for the poor student, lordship. And this businessman, lordship, they are earning money from that locality, they are refused to provide.
Okay,
lordship.
1-8, we are listing it on 1-8.
Highly obliged.
Okay, CDP call for 1.
Item 5.
My please lordship, my please behind the bar since 18 June, my lord. Now offense is under section 64, 77, 76, 71, 351, my lord. Lordship may come
Rape
to,
is also there.
I know. Lordship may come
He
to
is in custody since 1860.
18, my lord. The FIR, my lord, they post 14, my lord. Lordship may read in the submission, my lord.
Page 14.
14, my lord. So she is a married woman, my lord. That, happened to be my lord, cousin brother's wife, my lord.
Oh, it is a brother-in-law who
Ma-
committed rape.
My lord. Of rape, my lord, even then, my lord, allegation is not such a way, my lord. Since 1 year, she knows everything, my lord, but why she has lost the FIR letter, my lord?
His own, her own brother-in-law or?
Not on my cousin. Also in a period of detention and my lord, maybe whatever the offense, my lord, the custody detention, my lord is behind the bar, 35 days. And the FIR also lose, my lord, after 1 year, my lord.
After?
1 year, my lord.
After 1 year.
My lord.
When the offense.
Initially at March 20, 2024, my lord. Thereafter on 14 also, then FIR has been 17. Initially said that since March 2024.
Where from you are saying? The March 2000.
That mind in the FIR, my lord. Fourth line, fifth line, my lord.
আচ্ছা 2024 সনের মার্চ মাহ
My lord.
but lastly it was a date on 13/6.
13, my lord. 13, then the FIR was on 17. I was arrested on 18, my lord.
Otherwise, my difficulty is that at that point of time, he took some my lord, photographs, and now on the pretext of violating those photographs, my lord, he has committed the.
When the
That
64,
is
my
there,
lord.
but obviously if the rape was committed maybe
That
maybe she
compromise.
was also under compulsion. That
My
may-
At that point of time, he took those photographs, my lord. Now on the pretext of violating those photographs, my lord, at this point of time, he may be trying to commit the same offense again, my lord. On the basis of those earlier photographs.
now he is for more than 1 month I think.
1 month, 5 days, my lord.
Any sort that may be fixed.
My lord, well, maybe consider, my lord, because how she has lost the FIR, my lord. It says so, my lord. She is, my lord, the consenting party. If my so, then
Consent
let her.
means due to compulsion she may be
Otherwise,
there.
otherwise
Madam.
difficulty is that, my lord, he tried to use those earlier photographs, my lord.
Hmm.
And by using those photographs, now he tried to again commit the same. offense.
Why
This is the
March
difficulty.
27 not raised anything or not told anybody, my lord? Maybe, my
At
lord.
that point of time, he may probably not use those photographs. my lord.
And that, my lord, which date, my lord, the election is better. That day she has made it, my lord, if Facebook upload, my lord. She's okay, my lord, nothing is there, my lord. I have that, my lord, that video also, my lord. So if anything happened, my lord, against her will, definitely something, my lord, her mental state, my lord, is to be, my lord, considered, my lord. That day she has uploaded.
Uploaded? Who? She?
Her photo, my lord, where she is making party with someone's, my lord, on that day, my lord.
She was normally uploaded. those-
Not in my lord. The, my lord, whatever, my lord, consequence I'll face, my lord. I don't think so, my lord, this
31/7,
custody
I can-
detention is required, my lord.
On 30 or 31/7, my lord. Miss of date.
Want to periodic case diary.
Considering those, my lord, not because, my lord, incident is of, my lord, before 1 year back, because, my lord, at this point of time also, he is continuously involved in doing
Harassing.
those offense by using those earlier photographs.
Earlier, my lord, they are not saying, photos are taken earlier, on the last date, my lord. My lord,
Within
only
180.
prayer is that, my lord. Nothing to
Okay,
be, my
he
lord.
is saying that there may be something,
My
I
lord,
don't know if the photos are
photograph,
made
my lord.
viral.
Not viral, my lord. As per this FIR, shown to me, I'll viral it, my lord, not viral. I'll viral, that is a one kind of, my lord, yeah, intimidation, my lord. Not viral, my lord.
Okay, then heard Mr. M. Soronia, the learned counsel for the petitioner. And also heard Mr. P. Waterford, the learned additional PP appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. It is submitted by Mr. Soronia that the present accused petitioner is innocent and has not committed any such offense as alleged in the FIR. He further submitted that from the contents of the FIR itself, it is seen that the allegation of rape was brought, the alleged incident of rape was committed on March 2024. But even after a lapse of more than 1 month, she was silent and only the FIR was lodged only on 17/6/2020.
1 year, my lord.
He further submitted that the accused is in custody since 18/6/2025, and thus the Ayog was sufficient opportunity to interrogate him, keeping him in custody. Next, Mr. Botakud, in an additional PP submitted in this regard that the present accused petitioner had not only committed the offense of rape, but also had threatened the victim to threatened the victim and demanded for threatened the victim and
That will viral.
and also not only committed rape on the victim, but he also threatened the victim to make viral all the obscene videos and photos of the victim on 13/6/2025. Mr. Botakur accordingly submitted that a perusal of the case diary may be necessary to know the actual fact of the case. Mr. Horonia submitted in this regard that there may be the allegation of threatening, but till date, no photos or videos have been made viral, which revealed from the FIR itself. However, the petitioner is ready and willing to cooperate the IO in further investigation of this case if he is granted with a privilege of bail. Considering this submission made by learned counsel for both sides, other aspects of the case vis-a-vis the length of detention already undergone by the accused petitioner, I find it a fit case to extend the privilege of bail to the present petitioner. So and so to the satisfaction whom? Whose satisfaction?
It will be, my lord, I think, my lord, is Rungia's.
Yes.
Rungia, my lord, sub-divisional,
CGM Kamrup Rung.
not my lord, SDGM, my lord, Rungia, my lord.
SDGM.
আচ্ছা, SDGM বলি। কামরূপ পেকেটত আমিনগাঁও দিব। Okay, there will be some conditions, abide by all the conditions. Disposed of.
I love it.
Item 6.
Yes.
Allegation under 108 of Ethiopian, CD and medical report may be called.
108 is there
Yes.
and 80. Yes, when it can be called for, what happened? CD?
Can it be on first week of August?
7th of August.
August.
7th of August.
Item 7.
Yes.
483 application. One of the accused was behind the bar for 42 days.
Yeah,
and
two
one
petitioners are here. Two petitioners.
Two petitioners here.
Acha.
My allegation is that They are traveling in a auto
Huh?
and in the midst of journey, they have robbed the money from the auto driver. That is the allegation. And your lordship will find in from the arrest memo, 47, 48 has not been complied with. And it is also mentioned that they have mentioned 35 BNSS has not been issued to the accused person under the following circumstances. So all these things have 47, 48 has been not complied with. We are 37 days behind the bar.
Where from we are saying 47, 48 not compliant.
My lord, in the forwarding report, your lordship will find, I have written in my application, page 14, your lordship will find, it is, there is no mention, only grounds of arrest has been given.
No, this is the forwarding, in fact.
Forwarding only, and those things are not there. Only case
This
there
is
is.
your submission. I cannot say whether there was not.
Yeah, but had there been, they could have mentioned in the forwarding report, we have complied with. And your lordship will page 15, my lord, kindly. However, 35(3) BNS notice has not been issued even.
They have made some explanation. Made some explanation.
Explanation is given that arrest was necessary, arrest is necessary for proper investigation, arrest is necessary to prevent such person from causing the evidence of the offense disappear, tampering with such evidence in any manner. There is every possibility that will not appear at the time of the time of requirement.
So
they are the local.
Anyway, may be sufficient, may not be sufficient, but they brought some reasons for not complying with 35(3). Rest apart 47, 48, we cannot say at this stage from here.
Mention, madam. That's why if you lordship want that short date will give it from Bongaigaon.
CTB call for. List, yes.
My lord.
Short date to dictate.
7, 8. অলপ কম কৰি দিয়ক 31. My friend is posting for 31 July.
Demand is 30. He's saying 30 can be?
Yes.
Okay, 30. 30. Yes.
Regular violation under section 103, so relating to motor accident.
Say 103. So we have to call for the case diary. Okay.
8 months, 144 days.
How many days?
144 days. Charge already submitted.
Oh, it is charge sheet case. Oh, I thought how 140.
There, according report page number 23.
Anyway, it is charge sheet case.
Charge sheet case also.
Scan copy of the TCR we call for. Rest you will do the needful. List accordingly. Come on, no short date.
Scan copy of TCR and CD.
TCR and CD we call for. Rest you will do the needful.
27, 8. 27, 8 also many other cases fixed. 26.
5 months is running.
26.
At this stage, the evidence, no, evidence is going on there. Evidence cases at the stage of evidence now.
Lordship kindly see the one parallel.
22
number 20.
208.
23 Lordship. 23 is number 23.
Now, what are you going to show? What do you want to submit from 23?
26. I have perused the case record and it appears that the investigation this case is already complete and the IU had filed charge sheet against the accused under section 61 to 103 subsection 1. Proceed. Already.
That is admitted. The investigation is completed. That's why the charge sheet is there. And apart from that, the charge has already been framed and cases at the stage of evidence. So it is admitted. The investigation involved. But Whether his custodial detention will be required or not further, that is to be seen.
Lordship.
That is only to be looked into. So that's why we are calling for the case TCR. It will be listed on 2008.
2008.
Yes.
Lordship. Okay.
Supplementary cost list, motion DA, item number 60 and 61.
Now 61, he was submitting that one what we submitting 28.
28 Lordship, bail hearing, fixed.
He is submitting that it ought to have been listed on bail hearing column. But your one, I don't know. Your one is fresh, I think.
No, my lord, my one is also not pressed, my lord. CD already been received, my lord. Let me matter may.
CD already received in your matter.
Both-
But this is the in motion column, no?
Yes, my lord. Earlier also it was listed that day was, it was called for the CD, my lord. It was
Okay.
both the matters may kindly tomorrow fix.
Then he is saying that 28 is the date when the other matters are just.
That maybe, my lord. That 28 may let be hard on 28, my lord. This matter may hard today, my lord.
I don't know what I say. What I say?
Matter listed on today.
No,
my lord.
that
This
there
matter-
is what will happen, in fact, to consider some the parity, in fact.
But I am-
If it is the hard, can be hard together, then it is better, I think. I think so. That may be one of the aspects,
But
but
I-
I don't know.
44 days behind the bar, my lord, till.
Yes, that's why we are fixing it on 28.
Yes, sir.
Even if it is 60 days of it, I don't know, 60, 90, whatever, even if it is 60 days of it, then only your 16 days is still left. Okay, we are
It's
listing it
upon
on 20.
your lordship.
60, 61 দুইটা matter কৰি দিব বেলেগ বেলেগে কৰি দিব লাগিলে 28 7 this one day 28 7. Mr. Ahmed is submitting that there are two how many matters are there already? Two matters.
No, Lordship.
On 20 and how many other matters are fixed?
No, Lordship.
Well,
The, four accused. I am the APR on behalf of the three accused and one is the.
No, you are saying that on 28 7 one more matter is fixed. Which was the matter? For how many accused that was?
One matter is fixed, Lordship.
28.
More is other.
One matter. Okay, then we are listing it on 28 7. CDB retain till next date of listing. We are retaining the case.
Nine. Page of please, motion AB, item 10.
May I please, your lordship?
Yes.
My lord, in this petition, we have sought for transit anticipatory bail, lordship. Because lordship, as the alleged offence has been committed in the state of West Bengal, lordship. Lordship may kindly see page 19. I am served with a notice under section 41A, now it is 35(3), lordship.
Page number?
Page 9. Page 9. If I am not aware.
When you were asked to appear on 28 7.
Lordship.
Otherwise, these are cyber offense case, my lord.
Is there, but lordship, I am not involved, lordship, I have stated, and I am relying, I will approach the jurisdictional court, lordship. And I am relying on PI and judgment, lordship. On the basis of the guideline provided in PI and I may be enlarged on anticipated transit bill, I will approach the jurisdictional court, lordship, for a limited period, lordship. And lordship, in this regard, our honorable High Court also has passed many judgment. I have orders, lordship. I have annexed 2 of such orders, lordship, page 10. Page 10 and page 13.
Cases of West Bengal.
Lordship, wisdom.
This cyber crime.
Yes, ma'am.
File appropriate application before the jurisdictional court, my lord,
Yes.
without any protection, my lord.
No, no, Lordship. If I am not protected, the purpose of filing this application will be frustrated, Lordship.
Well, they are
So,
involved in committing.
what is your
this type of
apprehension?
crime.
Why you have been called for?
Lordship, I am sent service, served the notice, Lordship, at page 9, Lordship.
Hmm.
I don't know, I have nothing knowledge about the offense committed, Lordship. Now, my apprehension is that on the basis of this notice, I may be arrested. I will approach the jurisdictional court, Lordship. Till then, Lordship, I may be protected. That is my humble submission.
Not
And,
committed any offense
in this
going
regard, the honor. While passing similar,
Otherwise, what you do?
Lordship, I have stated in paragraph 2, Lordship. I am a mason,
You are a mason.
Lordship, paragraph 2, Lordship, I have stated. And our High Court also has passed similar order, Lordship may kindly see page 14, the relevant paragraph has been quoted in that order, Lordship. It is not a fact that I am seeking final bail. I am seeking some accommodation till I approach the jurisdictional court, Lordship, as per Priya Indure judgment. Lordship may kindly see paragraph 96. Page 803.
Heard Mr. M.I. Hussain, the learned counsel for the petitioner. And also heard Mr. P. Waterford, the learned additional PP appearing on behalf of state respondent. This is an application.
Only till, my lord, 28/7.
Pardon?
Only till, my lord, 28/7.
I have to go to the West Bengal, and that place is totally unknown to me. This is the motto of Priya Indriya. So, Lordship, I may be given some time. I have.
So and so. This is an application under section 482 BNSS for granting transit anticipatory bail to the petitioner in connection with Bidhannagar Cybercrime Police Station case number. Bidhannagar Cybercrime Police Station case number 83 of 2024 under section 419, 420, 406, 120B IPC. Most of this submitted by Mr. Hussain that the present accused petitioner is innocent and he is no way connected in any such offense, any offense. However, he received a notice from the Bidhannagar Cyber Police Station under section 41A CRPC, asking him to appear before the investigating officer on 28/07/2024 at 11:30 PM for interrogation. He further submitted that he had not committed any such offense or relating to cybercrime. But some days ago, one person, namely Hasmat Ali, took all his vital documents like voter ID, PAN card, Aadhaar card, etc., with an assurance to provide a job in the company in Boko of Kamrup district. That apart, he has not. No, but the person may somehow misused those documents, and he may be called for in this case. However, he is ready and willing to cooperate the IO, appearing before the Bidhannagar Cyber Police Station, and will extend his cooperation in the investigation of the said case if he is granted with some interim protection in the form of transit anticipatory bail till he appears before the jurisdictional court for his regular bail. In that context, Mr. Hussain also relied on a decision of Honorable Supreme Court passed in case of Priya Indoria. Priya Indoria reported in 2024 for SCC 749, wherein the court had observed that in para 96, that if a person that could be if a person commits an offense in one state and the FIR is lodged within the jurisdiction where the offense was committed, but the accused resides in another state, he can approach the court in the other state and seek transit anticipatory bail of limited duration. Next para. Mr. Waterford, the learned additional PP submitted in this regard that it's a cyber crime, the offenses of cyber crime, and hence the petitioner may be directed to appear before the jurisdictional court seeking anticipatory or regular bail to that extent. And accordingly, he raised objection in allowing the petitioner the privilege of transit anticipatory bail. Next point. Considering the submission made by learned counsel for both sides, and also considering the view of the Honorable Apex Court and other aspects of the matter, the present petitioner is accordingly granted with the transit transit anticipatory bail till interim transit anticipatory bail till 15 days from the date of order with a direction to appear before the investigating agency and before the Bidhannagar Cybercrime Police Station as directed, and the anticipatory bail will continue, and the protection of this anticipatory interim anticipatory bail will continue till next 15 days. That is till 15 days.
Lordship, may kindly do it 4 weeks because I have to
No,
go to.
no,
Lordship, I have to.
Not
go
at all.
West Bengal.
Till my lord,
And I need.
already date is fixed on 28th, my lord.
7, but if anyhow he may make a prayer, that's why.
Yes, on August 10, 24. Till 6th of August, my lord.
6th of August.
Till 6th of
It will be 15 days.
Yes, on my lord.
Not in. 9th August. 9th August was. He's saying the 9th of.
Holiday, my lord.
9th is
Saturday, my lord.
Saturday. Sunday is
On
11.
8 till 8th of August, my lord. 8.
No, let it be 9. 9 is holiday. 10, 11 of 11th of August. 11th of August.
And
11th of August. Enabling the petitioner to approach the competent court for seeking appropriate relief, public bail, and also to appear before the cyber police station. The present petition is accordingly disposed of. 11th of August, you are protecting, thereafter, I don't know.
Item 11.
Yes.
Lordship report was called for the whether any case.
Yes, Board Thakur, any report? Case registered? Under what is?
Summary, case number 61/25,
Summary of 61/25
25,
under section
under section 3163,
3163,
3183,
3183,
324/4,
324/4,
324/5,
324/5,
351/2,
51/2,
and 351/3. DBNs.
heard Mr. K. Thakur, the learned counsel for the petitioner, also heard Mr. P. Thakur.
Lordship, may I submit for interim lordship?
May P. Thakur, the learned additional people appearing on behalf of state respondent. It is submitted by Mr. Thakur that case has already been registered against the present petitioner under Missamari Police Station case number 61/2025 under section 3163, 3183, 324/4, 324/5, 351/2, 351/3 BNS. In view of this, let the CD along with the copy of the FIR be called for from the concerned police station. List accordingly when it can be. After
On
2
my
weeks.
lord, 13th of August.
13th?
13th.
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 I'm not interim, see lordship.
You are not an injury. You see these sections, they already are registered again.
Item 12.
13.8.
Lordship, the dispute was relating to agreement.
Whatever, I don't know. We are not in a
I
position
have
to say
annexed,
anything.
I have annexed the agreement. Lordship.
Of 13.8.
May I please, your lordship?
Hmm.
482 BNS's application, your lordship.
Hmm.
The FIR is at page number 10, the vernacular portion, your lordship.
FIR is at page?
Page 10, your lordship,
Check.
vernacular portion, your lordship. In your lordship, precisely the case is that, your lordship, 3 vehicles, your lordship. One is Swift Desire, one is Baleno, and one is Scorpio, your lordship, have been used to chase the complainant vehicle, your lordship. And finally, at market, Jamunamukh market, 20 persons inside the vehicle, your lordship, one inside the vehicle, your lordship, attack the complainant. That is the case, your lordship, precisely. Now, lordship, the FIR has been registered, your lordship, under section 191(2), 191(3), 126(2), 1182, 324, 109 of the BNS, your lordship. Now, your lordship, my involvement, your lordship, in this case, your lordship, I have been apprehended, your lordship, at paragraph number 3, I have pleaded, your lordship. Moreover, your lordship, what happened, your lordship, the Scorpio, your lordship, which has been used, your lordship, in this incident, your lordship, it was mine, the registration number, RC is at page number 12, your lordship. I'm the owner of that Scorpio, your lordship. And your lordship, in this second, my instruction is that, your lordship, one Jamaluddin, your lordship, have rented my vehicle, took rent of my vehicle, your lordship, for wedding purpose, your lordship. And in my vehicle, your lordship, one Ajibur Rahman and Asadul Islam is also there, your lordship, with my knowledge, your lordship. And other persons, regarding the other persons, if anyone there, your lordship, I don't know, your lordship. Now, my humble prayer, your lordship, the vehicle is still under Jamunamukh PS, your lordship. If your lordship kindly come to page number 12, your lordship, that is the RC, your lordship. Here, your lordship, it is a new vehicle, your lordship. That is has been purchased 5 April 2025, your lordship. Your lordship, what is my submission, your lordship, as the vehicle is very new and it was financed by Mahindra and Mahindra, your lordship. My case of absconding is cannot be possible, your lordship. I have to appear before the Jamunamukh.
So why with a new car you cannot chase anyone? With a new car, rather it will be very good in speed and all.
Is that because absconding part is not possible for me, your lordship. Because, your lordship, it is a new vehicle, your lordship, and it is before the Jamunamukh PS still.
How you are absconding? Absconding part, why not possible?
Because your lordship vehicle.
You from anywhere, if you fled from this place of residence, suppose, you can pay your EMI from the other place also, it's no bar.
Lordship, with due respect, what is my prayer, your lordship? Because your lordship, it is a vehicle, your lordship, which has been still under the custody of the police station, your lordship.
Yes.
So lordship, if your lordship kindly permits me, your lordship, to appear before the IO, so that your lordship, I can put my fact of the case, your lordship, whom I have rented my vehicle, your lordship, and other things also, your lordship. Your lordship, if anything found against me, your lordship may kindly reject this.
Lordship, CD lordship.
So your main case is vehicle is new, old, we are not on that.
Yes, your lordship, I have.
But your main contention is that you were not in the vehicle.
No, your lordship, I am not in the vehicle. One Jamaluddin, your lordship, even my name.
Why you changing the person?
Your lordship, Jamaluddin have taken my vehicle, your lordship.
Hmm.
I am not in the vehicle, your lordship. One Jamaluddin, he is known to me, your lordship. He taken my vehicle for wedding purpose, your lordship. And one Ajibur Rahman and Asadul Islam are also there in my vehicle, your lordship. Regarding the other person, I don't have any knowledge, your lordship, if anyone there, your lordship. But I know Jamaluddin, Ajibur Rahman.
So your vehicle is Scorpio?
Scorpio, your lordship. Scorpio. Because why I'm saying, your lordship, new vehicle, because number plate yet to come. And the FIR reflects the same thing. That's why I'm reading that my vehicle is new vehicle, your lordship. For that reason, your lordship, I have taken the plea, your lordship.
No,
Because-
why you were saying that new vehicle? Yes, new vehicle, then
Because
what to do?
your lordship, if your lordship kindly see the FIR.
No, what to do with new vehicle?
No, because why happened, your lordship? The FIR itself speaks. It was without number plate.
Okay, it's new vehicle. So
Lordship.
what about the new vehicle with this kind of, because your allegation is that with your vehicle and other two,
Another three.
the complainant vehicle was changing and then the assaulted and all, everything was there.
Lordship.
But you were saying new vehicle. So what with this connection with the new vehicle?
Because your
With the
lordship.
offense?
Yes, lordship. Because FIR itself speaks, your lordship. If your lordship kindly.
No, FI is all right. FI is says that it is without number plate. You are saying it is a very new vehicle. I
Lordship.
can understand.
Lordship.
But what is the connection with this offense? That's what I'm asking.
Your lordship.
New vehicle cannot commit an offense.
Lordship.
Then?
That was not my submission, your
No,
lordship.
you're repeatedly saying it's a new vehicle, new vehicle. FI is also reveals that it's a new vehicle. Oh, all right, new vehicle. But with a new vehicle, can a person cannot chase anyone?
Lordship.
That's what I'm asking.
Lordship, no, my what I try to convince this honorable court, your lordship, because it was reflected without number plate. First of all, your lordship. Second thing, your lordship, on 5 April 2025, that has been, lordship. For that reason, your lordship, number plate yet to come, your lordship. I have pleaded in my paragraph also.
Everything is understood, Ms. Purva. Everything is understood. I'm just
Lordship.
asking you what is the connection with the new vehicle and the offense? That's what I'm asking. Your vehicle is new, understood.
Lordship.
You are paying the EMI, understood.
Lordship.
As per the FI also, it is stated that your vehicle is new, understood.
Lordship.
Now, what is the connection? With the new vehicle, you cannot do any offense.
Lordship.
Then why are you repeatedly saying that this is my new vehicle?
Lordship, ma,
Understood, new vehicle.
Lordship.
We are not disputing it. It's a maybe new vehicle. With the new vehicle, it was changing.
Lordship.
You may not be there. Your involvement may
Lordship.
not be. That may be your submission. That
Lordship.
can understood. But with a new vehicle, one can commit any offense with the new vehicle.
Lordship,
What is the harm about it?
Lordship.
Heard Ms. G. Bora, the learned counsel for the petition. We also heard Ms. N. Das, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. It is submitted by Ms. Bora that the present accused petitioner is innocent and he has not committed any such offense as well as in the FIR. However, it is the fact that he purchased the Scorpio vehicle, which is in his name. And she also furnished one RC to that effect. But the vehicle was taken on rent for wedding purpose by one Jamaluddin. And as per her instructions, in the said vehicle, two more other persons, namely Azim and Ashadul, were also accompanying said Jamaluddin. But on the day of incident, he was not in the vehicle as it was given on rent to said Jamaluddin. The vehicle, full stop. The vehicle has already been seized in connection with this case. However, the present petitioner is ready and willing to cooperate the IO in further investigation of this case if he is granted with some interim protection. MS Das, the learned additional PP, submitted that to know the actual fact of the case, CD will be required, and accordingly, she insisted to call for the case time. Next paragraph. Considering this submission made by learned counsel for both sides, other aspects of the case, I find it a fit case to extend the privilege of interim pre-arrest bail till receipt of the case priority, and accordingly, so and so and so. Okay, you will be under interim protection.
Kind of place.
When it can be fixed?
On Lordship, 29 August.
29th of August. Appear before the IO, cooperate in investigation.
13.
30.
1-3.
May I please, Lordship? My lord, may kindly say FIR page 12.
Page 12.
Yes, it starts from page 8, my lord. But other things are there. Page is, first kindly see page 8, my lord. FIR against fake candidate found in SOS examination 2025. Respectfully,
You want to,
My lord?
which page you are insisting?
Page 8, my lord.
Page 8.
Yes.
The respect.
Lordship would say, I, the principal of Havli, Higher Secondary School, Havli, want to know that a fake candidate is found in the 3625 examination held in the ongoing HS level SOS. The information is given below. So, Shohidur Islam. My lord, may kindly say, this Shohidur Islam, it is, as per the FIR, it appears that he has been found, but actually, my lord, it is forwarded, Askar Ali, kindly say forwarding about page 14. Page 14. Lordship would say, forwarding of arrested accused person with prayer for judicial
Askar Ali.
Askar Ali. Now, my lord, in the examination hall, this Askar Ali was found, and Askar Ali said that I am the real candidate, and he appeared in my place. Now, Lordship may kindly see the sections. The sections, first Lordship kindly see 319. That is sitting by personation.
You have
That is
annexed the original FIR?
original affair, my lord. Original affair,
12,
maybe.
12. It's
12.
not visible, no?
Not so visible. But the translated copy is furnished. It may be visible if you lost it. What's that? I may read it.
No, you have already read.
Yes. Now, Lordship kindly see the section 319, that is bailable, my lord, sitting by personation. Second thing, my lord, that is 336, that is non-bail only. Only 340, that is also bailable. Now, the person who was found, kindly see first 319, that is sitting by personation. That was the earlier section 319 of IPC. So that is bailable, my lord. 419, that was earlier it was 419. Now 319. Second, my lord, 3402, forced document using it as genuine, that is also bailable. Third one is only non-bailable, that is 336, forgery. But what forgery I have committed? I am not in the hall. In the hall, Askar Ali is there.
Big forgery you have committed. Okay, CTV call for. CTV call for.
Unless some protection maybe.
No, it's not at all a case for protection. Yeah, person is there to sitting in the examination hall in the
But
name
in
of
the FIR itself, there is no
how this do you see the case, the gravity of the offense? It's not at all a case of interim protection. Yes, CD when it can be called for.
A short date may be.
We don't have any short date. Yes.
18th of August.
18th of August. So you are only for the side or now?
Yes.
18th of August. CDB call.
14.
One person is appearing on behalf of another person and appearing in the explanation. Is it a case for interim? Yes, Mr.
May I please, your lordship?
Yes.
Lordship, this is PRS bail application.
Hmm.
Page 12 is the FIR, my lord, finding to that.
Page 12.
12.
Hmm.
বিনীত সন্মান সহকাৰে আপোনাক জনাব বিচাৰো যে মই যোৱা ইংৰাজী 22/4/24 তাৰিখে গাড়ীগাঁৱৰ গাঁওবুঢ়াৰ পৰা নিৰ্বাসী ৰুবেনা বেগমৰ পুত্ৰ জিয়াউল আব্বাছ is the accused my lord here. লগত বিবাহ পাশত আবদ্ধ হৈছিলো, কিন্তু বিবাহ হোৱাৰ 3 মাহৰ পিছৰে পৰা মোক বহুতো শাৰীৰিক আৰু মানসিকভাৱে অত্যাচাৰ কৰাৰ বাবে মই যোৱা ইংৰাজী 25/2/25 তাৰিখে মোৰ ঘৰলৈ ঘূৰি আহি মাৰ ঘৰতে থাকিবলৈ লওঁ। তেওঁ বাৰে বাৰে মোক ফোন যোগে পইচা ডিমাণ্ড কৰে আৰু পইচা দিব নোৱাৰিলে প্ৰাণে মৰাৰ ভাবুকি দিয়ে। দুৰ্ভাগ্যবশতঃ 7/7/25 তাৰিখে সন্ধিয়া 7:30 মান বজাত উক্ত জিয়াউল আব্বাছে মোক ৰাস্তাত ধৰি চোঁচৰাই নি হেলমেট মোৰ শৰীৰত প্ৰত্যেকটো ঠাইত প্ৰহাৰ কৰে, যাৰ ফলত মোৰ মূৰত আৰু শৰীৰত বহুতো ঠাইত আঘাতপ্ৰাপ্ত হওঁ। লগতে মোৰ সোঁ চকুতো বেছিকৈ আঘাত পাওঁ। Actually, my lord, there is no any marpit. It is misunderstanding between husband and wife, my lord. An ego problem is there, my lord. She has left the matrimonial house and now residing with my parents' house. On that day, he requests her to come back. Says that I'm ready to continue conjugal life with you. Please, you come. That was the fact. No other marpit, nothing, my lord. No injury.
Yes.
Lordship, CD is required, Lordship, they have an inquiry, page 14, Lordship.
1/4.
Kindly bear with Lordship.
This is one inquiry report.
That is police report.
Husband of the complainant victim and the accused person always used to threaten to split acid on the complainant's face and kill her. On 7/7/2025, the accused person physically assaulted the complainant victim while the complainant was walking alone in the road of Sodiapur Riverside and 7:30 p.m. As the result of physical assault, complainant clothes was also torn, which I have seized from the complainant's mother, and complainant was still under medical checkup. Sufficient evidence
Medical
has been
checkup only.
found against the culprit, Lordship.
No any injury here mentioned. Medical checkup only. That is there.
CD may be called.
Heard Mr. B.B. Gogoi, the learned counsel for the petition. And also heard M.S. Anders, the learned additional PP, appearing on behalf of state respondent. Here is an application under section so-and-so in connection with so-and-so. Considering the submission made by learned counsel for both sides, statement made in the FIR. I find it a fit case to extend the privilege of interim pre-arrest bail to the present petitioner till receipt of the case file. Like so and so. Okay, you will provide it with the interim. When it can be fixed.
27. 28, Lordship, 28.
28. 28. There will be some conditions about by all the. So last one,
Item 50.
Yes. Please. Yes.
The lordship will turn to page 15.
1/5.
1-1-2. Where?
1/5.
1-2.
12. Okay.
In vernacular, my lord.
Yes.
May I read, my lord? সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱা 28/6/25 তাৰিখে ৰাতি অনুমান 12টা মান বজাত মোৰ নাবালিকা ছোৱালী আলিমা খাতুন বয়স 15 বছৰ 6 মাহ মোৰ নিজ ঘৰৰ পৰা নিম্নলিখিত 2 নং পদকীয়া জনৰ সহযোগত 1 নং পদকীয়া জনে প্ৰেমৰ প্ৰলোভন দি অপহৰণ কৰি লৈ যায়। উক্ত ঘটনা সংক্ৰান্তে আমি ৰাতিপুৱা খবৰ লোৱাত জানিব পাৰো যে সোয়াঞ্চো গাঁৱত গৌৰীপুৰ থানাৰ অন্তৰ্গত খয়ৰা গাঁৱত তেওঁক পোৱা গ'ল। In my
Case
village,
is registered only under which section?
my lord, registered under section 96.
POCSO is added here? No.
No, my lord. 96, inducement of child to sexual intercourse, etc.
That is 366A.
That.
Earlier 366A.
366. And now your lordship, 96, now your lordship, would you please to see another section 3 within bracket 5.
Just
Communication.
is there any statement that the girl was recovered?
Girl recovered, ma'am.
Where from you're saying?
I have stated.
No, your statement is there. Is there any?
My lord. My lord, document I could not produce, but this is the affidavit, on affidavit I am telling, my lord. I know the girl and the girl is recovered, ma'am.
But at
And
present, we don't have anything.
She is with parents, my lord. She is with parents.
At present.
Yes, at present. My humble submission before your lordship. If on
One thing,
affidavit.
at present,
lord,
definitely,
regarding-
maybe with her parents.
Yes, my lord. Regarding
And
your
but
lordship,
if you
regarding
go
her
by the
recovery-
FIR, and the documents, it is not clear whether she was, she has been
in
recovered
in
or
the
not.
parents, my lord. So, my lord, I humbly submit before your lordship on affidavit. I am giving on affidavit that she is recovered and she is with parents. On affidavit, I am telling before the Honorable High Court, my lord. If anything goes wrong, my lord, I will be liable, definitely. I will be in problem, another problem. My lord. So, my lord, I will not dare that girl is not recovered, and for getting bail, my lord, I will say before your lordship on oath that girl is recovered, my lord. That is my humble
Yes,
submission.
Lord. Submit.
So, my lord, entry protection may be given, my lord. And another thing is this, my lord, 164 statement along with medical report may be called for.
What do you submit? What to say?
The parents' pleasure.
Heard Mr. M. A. Sheikh, the learned counsel for the petitioner, and also heard Ms. Anders, the learned additional PP appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. It is submitted by Mr. Sheikh that the present petitioner case is lodged with some false and concocted allegations. And he has submitted that on on oath it is submitted by the petitioner that girl has already been recovered and she is with the parents at the present time. However, the present petitioner is ready and willing to cooperate the IO in further investigation of this case if he is granted with some interim protection. Next, para, MS does still an additional PP submitted in this regard that CD may be called for to know the actual fact of the case and about the recovery of the victim. Considering this submission made by learned counsel for both sides, other aspects of the case, I find it a fit case for it. Okay, you will be under interim protection. You are on oath, you are saying that you are submitting on own oath. That's why we are considering if it is anything is there, then definitely it will be a case for, otherwise it will be taken up.
My lord.
If the girl is not yet recovered.
Interim protection is given.
Interim will be given.
Oblige your lordship.
9 lordship.
29.
29.
29.
My lord, my humble
29
submission
44.
before your lordship, my information is this, my lord, 164 statement is relevant and this
It will
medical.
come, it will come.
Yes, my lord,
It
that
will
may come, call for, oblige your lordship.
You.
16.
Yes. Non-FIR case, Lordship. Report will be called for, Lordship. Apprehension is under not locking.
And from which state police station?
Not locking police station.
Not locking.
Yes. Lordship. Petitioners are husband and wife, Lordship.
Both the petitioners. Both the petitioners.
Both petitioners. Husband and wife, Lordship. They are on apprehension that the mother of the petitioner number 2 may have lodged FIR against them, Lordship, because police is searching both of them. They got married against the will of the parents of the.
They are not major?
They're major.
Major. So it's
Still
okay.
police
then.
is searching, Lordship.
It's not the case that
Any
the religion wise also it's not there.
What is there in the FIR? We not.
They are not appear.
Whether police is searched or not, that is also. Police is searching, Lordship. They are in agreement.
Heard Mr. K. Thakur, the learned counsel for the petition, and also heard Mr. B. Sharma, the learned additional PP appearing on behalf of state respondent. This is an application under section 482 BNS for granting various bail to the petitioners. It is submitted that by Mr. Thakur that the police is searching for these two petitioners and there is an apprehension that any non-bailable case may register against the present petitioners in the North Lakhimpur police station. North Lakhimpur police station full stop. Next, in view of this, later report be called for from North Lakhimpur police station as to whether any FIR or case has been registered against these two petitioners. The learned additional PP, Mr. Sharma will take necessary steps in procuring the report from the concerned police station. When it can be listed?
Can you on Monday, Lordship, telephonic instruction only, 12 August, after that. Telephonic instruction.
No, my lord, it is-
only.
It
Thereafter,
is
the
easy
case
to
that-
say, my lord, to telephonic instruction, my lord, but we will send requisition, my lord. And from where IO is there, where the petitioner is, where is the petitioner, my lord, to verify, my lord. From record also it was required, my lord. OC said that we will have to verify the record. OC is in the, in some inquiry or investigation. He is outside. That is the thing, my lord, but it is not easy to say telephonic instruction, but it is not possible for us also, my lord. We pray for 3-4 days at least, my lord.
First week, Lordship, August, Lordship, 3-4 weeks.
We have a session these 2 weeks, actually, we are not supposed to list any matter. This is the instruction from the registry also. I mean, especially the ABs, BA2 definitely. It was your 11th of August. No, 11th of August.
License.
May I please, Lordship?
Yes.
The anticipated bail application, Lordship. Here, Lordship, except section 132, Lordship, 1182 and 109, the other section are bailable, Lordship. The allegation.
Several sections are there, na?
7 sections. Out of the 7, Lordship, 3 are non-bailable, Lordship.
Hmm.
The allegation in short, Lordship, and as ASI of police lodged this FIR, Lordship. Alleged that, Lordship, a villager informed the police that a bizarre is going on that village, Lordship. And one man and woman was assaulted by the villagers, Lordship.
We have
And on the basis of the same, Lordship, the police came and as per police, there is an altercation between the villagers and the police, Lordship. That is the allegation, Lordship. Here,
villagers
Lordship,
and the police. Or two groups, or villagers or police. Where is the
villagers or
FIR?
police,
FIR?
Lordship. FIR is
Yeah,
page
we
11,
have
Lordship.
come across this FIR, I think, that's why I'm just.
Yes, Lordship. Here, Lordship, I am
Some
the.
Dole, na?
Yes, Lordship.
Dole.
I am a TMPK member, Lordship. So, Lordship, my name is Derek in the FIR, Lordship. Totally, I am not involved in this case, Lordship. The actual-
Ranjan Borua বাহুত গুরুতর জখম পায় injured.
No, this, in connection with this FIR, we have called for a case diary.
Yes, Lordship.
When, do you know? Do you know the date?
Yes, Lordship. BA number 2261.
BA?
BA number 226125.
2261/25, when it is listed, can you tell us? This month.
Protection to be given, Lordship, because I'm
Not at
the
this.
villagers, Lordship. More than 200 villagers were present, Lordship.
That's why we got to peruse the case.
Let
diary.
me
Your
put it on
involvement did not
Lordship,
fit
short
in.
it. It's already given.
CDB call for list on 3107
All the
2025,
accused person are
along with BA number
Arrested, Lord.
2261 2025. BA 2261 2025. 31/7. Yes.
My lord, this is a matter. My lord, say, in fact, there is a matrimonial dispute between the husband and wife. I'm the wife, my lord. Now, what happened, my lord, on that particular day, the husband went to my residence. I'm a school teacher. Now he was, my lord, banging on the door. And by force, he opened the door and started to beat my son. He's aged about 8. Then I was in the kitchen. I came out from there. Then there was a scuffle between the husband and wife. And there he sustained some injury. I have also sustained some injury. Now, your lordship, kindly see the FIR, contents of the FIR. At page 22. my lord.
It's not available here.
The incident occurred on 4/6 and the FIR was filed on 2006 to 2025. Page 22, your lordship got it. I, the undersigned, would like to state the few lines for your necessary action. On 4/6/2025 at 4:55 PM, when I went to meet minor son, namely Master So-and-so, at the residence of teacher quarter of Bloom's Play School situated at Bhavan Gagaipat, that is Tinsukia, where my wife is working as a teacher. I went there only to meet my minor son, who is presently with my wife, Srimati Madhu Chaya Chakraborty, daughter of so-and-so, at the aforementioned address at Tinsukia. And she is also a permanent resident of KP Road, Namghar, district Dibrugarh, Assam, having mobile number so-and-so. That I called my son, and while I was walking with my minor son, all of a sudden my wife attacked me with a sharp weapon, that is a kitchen knife, in my neck, below my chin from front side, with the intent to murder me. As a result, I was grievously injured, and my skin and muscle got torn below my chin due to sharp deep cut of my wife's kitchen knife, resultantly to heavy blood loss of mine. So the whole incident happened in front of the eyewitness, my minor son, Mr. So-and-so, nearby people of my wife's quarter of Tinsukia, who immediately came to the place of occurrence, who are residing nearby to the quarter of my wife. Now, the photographs, your lordship, kindly see these two lines, his mindset, your lordship, kindly see. Now, the photographs of my injured body with blood stain and video of the incident taken by me in a pen drive downloaded from my mobile phone. In that particular time, he had the mindset of, my lord, taking the video and all that. That is his mindset, my lord. Having phone number so-and-so enclosed with this FIR submitted before the police will speak the truth of the incident and also the criminal nature of my wife. In the same day time at about 5:12 PM, the nearby people of my wife's quarter took me in the auto rickshaw to Lokapriya Gopinath Bordoloi Civil Hospital, who admit me where the principal and others of Bloom's Play School inquired about my well-being, and on the same day brought me to my family members at Dibrugarh at Bloom's Play School staff, Sri Achyut Borua, by said school's vehicle, and thereafter I was admitted to the Apeksha Hospital near so-and-so by my family members, where neck surgery of mine was done. The several stitches and the photo of the said stitch of my neck is enclosed with the FIR. The mother of my wife, namely, now, your lordship, kindly see the mother has been implicated without any reason. Your lordship, kindly see the language. Mother of my wife, namely Tamasha Chakraborty, wife of Manoranjan Chakraborty, permanent resident of Kapiru, near Dibrugarh, Assam, having mobile number so-and-so, is already actively involved to ruin our married life and always supported my wife's criminal acts prior to this. Now, in this incident, she has no role. In spite of that, she has been implicated to lodge false case against me and never allowed me to meet my minor son, Master So-and-so. The delay of lodging the FIR, now regarding delay, he has explained. Now, your lordship, kindly see in the page at 29. This is the case where, my lord, I filed an FIR when on 22/11/2023, he came to my paternal house and started beating everybody. Then we filed the case under section 498A. The charge sheet has been given under that case, my lord. Now, at page 30, your lordship will find he has filed a divorce case which is pending. This is titled suit 52 of 2024. Then, my lord, your lordship may see at page 30B. In that scuffle on that particular day, that is on 4/6/2025, I also sustained injury. Your lordship will find that physical assault by husband Has your lordship got that? Then the cut mark on right arm, then the lacerated injury in the left ear, then the pain over back. Now, in fact, my lord, what your lordship will find that there was a scuffle on that particular day, and I also sustained injury. I've also filed an FIR. My lord, that FIR I did not have a written down. The FIR is having with me, my lord, your lordship can see that. And then she has narrated how it has happened. Lordship may see that at this stage, my lord, my prayer would be, my lord, this is in the context of, my lord, the dispute between the husband and wife. All these things have been happening. So, my lord, it's a case where the interim measure, your lordship may grant the interim bail both the persons. And my lord, your lordship may direct that within 15 days they will appear before the IU for any custodial interrogation and all that. Possibly, my lord, it's a case where your lordship will not see that it's a case of attempt to murder and all that. Because the dispute have been going on for a long time, right from 2017. And they have a school going boy, my lord, he is also not in a position to attend the school because of these problems. Because the lady, after all, my lord, in order to, my lord, protect herself from the police, she's hiding somewhere else. So therefore, if your lordship pass an order protecting me, and in the meantime, within 15 days, I will appear before the IU, whatever the interrogation is to be.
Lordship, mother may be given interim protection, Lordship, and Lordship CD with injury.
And the incident occurred, my lord, due to scuffle between both the parties. It's not a case of, my lord, any attempt to murder or whatever.
So what section the case is registered?
Yes, that your lordship will find section 118
That is
and
grievous.
109 of 118 is grievous injury and 109 is my lord, attempt to murder.
Heard Mr. S. Dr. Delaney, Senior Advocate, assisted by Ms. K. Bora for the petitioners, and also heard Ms. Anders Delaney, additional fee appearing on behalf of state respondent. This is an application in section so and so in connection with so and so. Post Mr. Dr. Delaney, Senior Advocate, submitted in this report that the accused petitioner number 1 is the wife of the informant, and the accused petitioner number 2 is the mother-in-law of the informant. It is a fact that there was a matrimonial dispute is going on between both the parties since 2017. 2017, and the informant had already lodged instituted a divorce suit seeking divorce, and in the same time the petition number 1 also lodged one case which is registered under section 498A IPC and pending for disposal. He further submitted that on the day of incident, there was a quarrel and scuffle took place between the parties when the informant visited to meet his minor son, and both the parties, they sustained some minor injuries in that event, in that case. He also submitted that the present petitioner also took the medical treatment, and to that extent, he also submitted furnished one photocopy of furnished one medical prescription poster. Mr. Doctor further submitted that the accused petition name of the accused petitioner number 2 is Anton Hill without her any involvement in the alleged offense, only because she is the mother of the petitioner number 1. It is completely a matrimonial dispute, and the petitioner has not committed any such offense as alleged in the FIR, except alleged in the FIR. However, it is a fact that this scuffle took place between the parties. Both the both the petitioners are ready and willing to cooperate the IO in further investigation of this case if they are granted with some interim protection. Next paragraph. MS does an additional PP submitted in this regard that petitioner number 2 may be given some interim protection, but there are sufficient incrimination against the petitioner number 1, and hence she submitted that CD will review the actual fact of the case and insisted to call for the case diary. Hearing this submission made by the counsel for both sides and aspects of the case, including the annexures filed along with the petitions and the petitions, I find that some interim protection may be provided to both the petitioners, both the petitioners accordingly, DD till receipt of the case diary, accordingly DD. Not 15 days, within 10 days.
Well,
Yeah. Then it can be called. 3 days.
much obliged.
CTB called for 3 days. Yes, obviously, to the.
May I please withdraw the motion?
Yes. Kali কিমান লিষ্ট হৈছে এবি অলপ কমাই দিব লাগিব এবি খুব নেম লাগিব কালি গুটি গাই এবি বহুত এবি ঠিক টাইম বহুত লৈ যায় আচলতে এতিয়া সবতে সাবমিশন থাকে না প্ৰবলেম কি এটা বস্তু হা ওলাইছে নেকি অলৰেডি হয় নেকি Monday.
Lordship, it's Dholai Police Station, case number 54 of 2025, under section 329(4), 127(2), 117(2), 118(2), and 35 of BNS Act. Lordship, these petitioners are not FIR named accused. The two co-accused persons are already on bail. Lordship, kindly come to the FIR. The incident took place on 2nd April 2025.
Where's the FIR?
Lordship, I
Page,
annexing page number 11. Lordship, it is alleged that the complainant husband was beaten by these petitioners, and as a result, the husband was seriously injured and admitted in hospital. This is the allegation. The principal accused are on bail, Lordship, and my petitioners are not FIR named accused.
So why you are apprehending? Why there is any apprehension of your that you may be arrested? Why?
Lordship, we are suspecting that they might get arrested because they were on the incident.
They were also present, that means.
It is
took
alleged
part.
that they were present. It is alleged that they were present.
Not alleged. Where it is in the allegation.
But in
It is not
FIR, it
alleged
has not been
that,
stated.
That's what I am just asking you.
Lordship, in FIR, it has not been stated.
It has not been stated.
Where is the apprehension?
Where is the apprehension? Because it's repetitive, it is saying that accused persons, and 3 accused persons has already been named.
Lord.
So where is the apprehension?
Lordship, the officers came to my house and searched for us. They made queries for us, Lordship.
Yes, that's what.
So I've stated in paragraph 4, Lordship.
Let him appear.
And they can appear. So you are in relation with the other prime accused persons.
No, Lordship, I'm not in relation.
The title is similar,
What if
title
they
is similar,
happened, Lordship?
seems to be. You have not gone through the record properly, I think. It seems to be. Because title is similar.
Lordship, it is suspected, but it is appear.
No, I am saying that are you in relationship with the other co-accused persons? Is there any relation? Are you relative or anyone? You don't have any instructions.
No, I don't have any instruction.
And you have not gone through the record also.
CD, Lordship. Then Lordship all for this?
Yes, we don't know how they are
Yes,
related.
Lordship. What is their involvement? Lordship? Only CD, Lordship.
We are giving you a short date, otherwise we're trying to give you, I don't know, city will call for when it can be called for.
Lordship, let the interim bail be continued then.
Are you on interim there?
No, Lordship.
Lordship, I'm not.
You are not on interim, that's why we're trying to give you a short date. Okay, so I take my apology. 6th of August.
6 August.
6th of August.
Lordship.
You could not bring any apprehension, no, that's why I'm asking. 60. I call it for the case diary.
Grateful, Lordship.
May I please, your Lordship? FIR, Lordship, is at page number 14, Lordship.
FIR is at
Page number 14, my lord.
Yes.
Very small FIR, may I read it, Lordship?
With
due respect, Hamil's submission is that on 2/6/25 at night, my minor daughter, so-and-so, went missing from residence. I suspect that one Idris Ali, son of so-and-so of our place, has taken away my minor daughter by interest. Case is listed under section 140. Idris Ali is not before your lordship. The petitioners before your lordship is the friends of Idris Ali, lordship. Now, lordship, that victim girl, lordship, has been recovered, lordship. Lordship may kindly come to page number 22. Page number 22 under 11/6. Eleven six 2025 order dated, my lord. This record so-and-so for recording the statement of the victim girl. And accordingly, the victim girl, aged about 16 years, is produced before me, being escorted by so-and-so. The victim is given 1 hour time. Therefore, thereafter, lordship, 4th paragraph. On being asked, the father of the victim showed his interest to take the zimma of the victim. Accordingly, he is allowed to take the zimma. So the victim has already been recovered, lordship. And lordship, the case is that, lordship, that Idris Ali and the victim, they eloped away, lordship. As because, lordship, Idris Ali as well as victim girl, they have not attained the age of majority, lordship. Therefore, they could not solemnize the marriage, lordship. And because of that, lordship, out of frustration, the father of the victim has recovered, has filed this petition, has filed this case, lordship. We are the friends, lordship. We will appear, lordship. Victim is already recovered, lordship. No kindly grant us interim protection.
Mr. M. Ahmed, Learned Counsel Petition, and also heard Ms. Anders, Learned Edition PPM on behalf of said respondent. This is an application under section so-and-so in connection with so-and-so. It is submitted by Mr. Ahmed that the present accused petitioners are not the FI named accused and they are not connected with the arrest offense. However, they are the friends of the accused, namely the FI, and only for that reason the police is searching for them. The girl has already been recovered, which as revealed from the order dated 11/6/2025, passed by learned JMFC Dhupri in GR case number 898 of 2025. If it is submitted that both the informant and the victim had the love affairs and they eloped together. But as the girl was not as the victim girl and the accused was not at a marriageable age, the father of the victim lost the FIR. However, both the petitioners are ready and willing to cooperate the IO in further investigation of this case if they are granted with some interim protection. So and so corridor. Okay will be under interim protection, appear before the IO and cooperate in the investigation. When it can be
4/9.
4/9.
Within 10 days?
Within 10 days.
Highly please.
Item 21.
May I please, Your Lordship? This is the PAS bail application, my lord. The allegation lawsuit will find at page 14, that is the FIR, my lord, Annexure 1. And operative person started from 17, my lord. My lord, kindly see the date first, my lord, 14 July 2025. My lord, this FIR has been lodged on 14 July, my lord. I am reading the FIR, my lord. With due respect, I would like to inform you that I am Sri Rajesh Kumar Agarwala, son of late Mahavir Prasad Agarwala, aged about 63 years and permanent inhabitant Radhia Babu Land, 80 Road, opposite PO Jorhat, PS Jorhat, District Jorhat, Assam. Sir, I would like to state that the said Gajanan Goju Mundra and Nanda Kishore Mundra, there is a two accused, my lord. Mundra took shop on rent from the year of 2007. A tenancy agreement was made dated first day of August 2016, which was completely fake, forced, fabricated, and manipulated, and made by Nanda Kishore Mundra. Copy of the fake forced tenancy agreement is attached here with. In the year of 2024, it came to my knowledge that both the accused persons submitted fake, forced, fabricated, and manipulated documents for issuing of the trade license from the municipality board, Jorhat. The accused person made the struggle illegally to gain the trade license by using the sitting and got issued the trade license by the concerned authority by using the sitting. This three paragraph is important. Later on, I came to know from reliable sources that they have submitted fake tenancy agreement to get the trade license from municipality board. So I have complained to the chairperson by complaining letter dated 10 June 2024, copy and quote. For the several months, I did not got any positive response from the concerned authority. So I again sent them a reminder letter on so and so date. After a negligent attitude of the concerning authority, I was compelled to send a legal notice through my legal counsel on 2/6/2025. Copy of the legal notice is attached here. That, my lord. After that, my lord, police has registered this case on the date as under section 468, 471, 506, and 34 of IPC, my lord. And thereafter, prior to that, my lord, what happened, my lord? Kindly turn to next page, my lord. He has lodged another affair, my lord. Prior to this affair, my lord, another affair. In that affair, my lord, allegation against us. Allegation for extortion, my lord. And that affair, lordship will find at page 22, the relevant portion. And after filing this affair, my lord, police has registered a case and as Jorhat Police Station case number 308 under section 3082 of 5 of BNS, my lord. And after that, my lord, we have approached your lordship, my lord. Kindly peruse the annexure 3, page 24, my lord. My lord, in the bottom, my lord, on that day, my lord, on 14/7/2025, my lord, the accused number 2 was appeared before the IO. On that day, my lord, this affair has been lost, my lord. Why this affair has been lost, my lord? Kindly turn to page 25, my lord. Page 25, paragraph 6, my lord. In the bottom, my lord, page 25, my lord. This is the lordship's order. Having noted that there is a discrepancy in the case projected in the affair dated
18/6/2025 with the contents of the notice dated 2/6/2025. Only that basis notice he has mentioned in the present case. I am coming to that point, which is annexed with this PRS bail application as Annexure 5. The court is inclined to grant interim PRS bail to petitioners by providing that in the event of their arrest, the petitioner, namely Sri Gajanan Mundra and number 2, Sri Nanda Kishore Mundra, in connection with the aforesaid case, they shall be released on interim bail by furnishing the bail bond of so and so is to solvent sureties like amount to the satisfaction of the arresting authority. And my lord, there is some conditions was imposed, my lord. Condition number F, my lord, in the bottom, my lord. The petitioner shall appear before the IO within 7 days from the date of this order, failing which the PRS bail would be left by the influx of time. My lord, on the 14, my lord, petitioner number 2 in the present case appearing, he has lost the case. Police has registered the case under non-bailable section. And prior to that, my lord, the agreement in question, which is called as the fake documents, I have annexed at page 28, Annexure 4, my lord. This is the agreement, my lord. And my lord, what happened, my lord? On the basis of that agreement, we have applied before the Jorhat Municipality Board for trade license in the year of 2016. And Municipality Board has given me the trade license. My lord, kindly turn to page 30. This is a type copy, my lord. I have annexed the photocopy of the original one. This trade license, first trade license was issued on 16/8/2016, my lord. We have entered in the agreement on 1st day of August 2016, my lord. And it is known to him, my lord. It is please turn to page 34, my lord. This is the original one. This is the first trade license. Trade license number is 9377. Earlier, my lord, my trade was for kitchen appliance, and this is the number in the there is a table, my lord. This is the renewal dated 16/8/2016, 2/11/2018, 3/8/2019, and later on, my lord, in the year of 19, my lord, I have changed my trading, my lord, and my trade license number has been changed. That is at page 35, my lord. And this was renewed up to 23, and later on, my lord, onto page 36, my lord, my trade license has been renewed till the license is renewed till 3/30/2025. My lord, when we have approached the authority for renewal of the trade license for the year of 2025 and 2026, my lord, the authority refused to renew my license. Jorhat Municipality Board refused to renew my license on the basis of the complaint lodged by the present informant, my lord, present complainant, my lord. And then, my lord, we have approached your lordship, my lord. Kindly turn to page 37, Annexure 6, my lord. This is the lordship's order. This order disposed of by your lordship, my lord, I am reading the order, my lord, very short order, page 38, my lord. Had Mr. D. Bubra, learned counsel for the petitioner, who submits that the petitioner is running a cloth and ready-made garments business in the name and style of the RD Trading Company at the rented showroom at RB Land, Jorhat, by executing a tenancy agreement with the landlord, respondent number 5, where, my lord, the complainant has been entitled as the respondent number 5, my lord. Lordship, that is at page 37, Rajesh Kumar Agarwala. He was also inducted as the respondent number 5, my lord. The petitioner's counsel submit that the respondent 3 has not taken any decision on the petitioner's representation on account of the respondent number 5 having apparently raised some objection for the renewal of the petitioner's trade license. The petitioner's counsel submit that the writ petition can be disposed of if the petitioner's representation dated so and so is decided by the respondent number 3, until the decision is taken by the respondent number 3, the petitioner should be allowed to continue running his shop. Paragraph 4, my lord, in view of the consent of the parties, the respondent number 3 is directed to take a decision on the petitioner's representation dated so and so within a period of 1 month from the date of the receipt of the copy of the order, which shall be furnished by the petitioner within a 1 week from today.
So what do you want to submit, in fact? It's a very lengthy submission. It's
Yes,
all-
lordship,
all-
my lord, my
all jumbled up.
on
What do you want to submit?
want to submit is that, but on the while this petition has been a complaint has been lodged, my lord, complaint is the false documents, and that documents lordship has already observed in the writ petition that the chairman will take the decision on the basis of the complaint filed by the complainant and of the petitioner in presence of both, my lord. It is still pending, my lord. And while he has stated one legal notice has been served to me, my lord, on 2/6/2025. In legal notice, not a single word has been mentioned regarding that particular false document. Nothing. Earlier FIR for extortion, now legal notice, nothing. And on the basis of that FIR, my lord, Nandakishore Mundra has been arrested on 14th. And he was produced before the CGM, my lord, on the next day. And CGM has granted the bail on the first day. Kindly see this order, my lord. What the CGM has observed, my lord. My lord, kindly turn to page, my lord, very long order. I am reading only two paragraphs. Upon hearing both sides and going through the documents annexed to the SIR as well as to the bail application, it appears that there is a dispute between the informant and the accused regarding outstanding rents of the tenant and premises and trade license and tenancy agreement. Considering the facts and circumstances of the case, the nature of the offense, and having going through the documents annexed to the SIR as well as to the bail application, I have not found cognate ground for remanding the accused to police custody or judicial custody. Rather, I have found it appropriate to grant bail to the accused for an interim period. Accordingly, accused is allowed to go on interim bail of rupees so and so with a suitable surety of like amount and default to be remanded to the judicial custody with the
One
following
case was
conditions.
there, na? This
Well, in the meantime, my lord, case there may be called
out of this FIR. One more case is before this court. Out of the same FIR.
yes.
Can you remember?
But yesterday, my lord, this bail has been absoluted, my lord. In respect of the accused number 2, my lord, by CGM Johar.
At this stage, Lordship, let the city come, Lordship, as they have submitted fake tenancy agreement, Lordship, to get the trade license. Lordship, let the city come, Lordship.
Now you're saying that in the writ petition, that matter is pending.
Pending before the chairman. This is the at page 39, paragraph 4. I have submitted this before the authority, my lord. Certified copy. This matter is already been decided by your lordship, my lord. Paragraph 4, my lord. Page 39. But only to my lord, make the obstruction in respect of the condition F in the earlier order 10/7/2025, my lord. On 14, my lord, he has lost the FIR when we have appeared before the.
It will check one. This petition I have filed one more matter was filed in fact. To facilitate ne kono batwe there was one. আমি পাহৰিলো মন পাহৰিলো sharp আছে বেলেগ যাওঁ তেওঁলোকে পাহৰি গৈছিলে কোনজনে লৈছিলে মোৰ মনত নাই লৈছিলে এওঁ মনত নাই তেওঁবিলাকে লৈছিল নাজানো কোনোবাইতো লৈছিল I don't know who was there. In the FIR, we have another matter was there. Out of the same FIR. She may not be there, I don't know, but who was there, I just cannot say, but I generally, my memory is sharp, so I know that this one is, one petition is there. One more petition was there in fact,
In respect of this FIR Lordship,
this FIR.
no, my lord. No, my lord.
No, you may not be there.
Court use order has been passed by CGM Jorhat, my lord.
No, not serious.
And as per my instruction, my lord, only this is.
Someone was introduced by someone, that was the case. Not the named FIR, his name was not there. But someone was there who introduced someone, that was the case. Case number is Jorhat.
Jorhat PS is number 357.
7.
That is the case. Jorhat PS is number 357. One thing, it's number 9, 10 above.
Case of the one, AB 1720.
That is another FIR. I have annexer 2.
No,
Regarding the present affair, only one case number AB 1724.
this is 1724.
Yes.
That in connection with the other FIR, this was shown or what, but I have gone through this one. Yes. Which is the other FIR? Extra FIR?
Annexer 2, my lord. At page 22, that was lodged on 18/6/2025, and the lordship will pass the order on 10/7/2025. Annexer 3.
It is one another Jorhat PS 308.
Yeah, that is annexer 2.
Is AB number 1639/2025.
Yes. This is annexer 3.
135 annexer 3.
AB number?
Number 1639.
16 na kuntu?
1639
Not this
or
case.
1539.
153.
1535 annexer 3.
The present case is no regarding
1535 is there any? 1535.
AB 1535 in connection with 308 Jorhat PS case number.
মানে যিনি ইন্ট্রোডিউস করেছে যে ওয়ান ফ্যাসিলিটেট করেছে
Yes.
দেন ওখানে
1535 বোঝানোর মতো।
And নামটা কিছু মনে হয়।
It is my lord, FIR number 308. Regarding
It is not, the order was not passed by this court. Yes, court did mention passed the court. It is that one, other one. But in your other writ appeal is a connection with other matter, that is the, in regards to
petition
renewal
in
of the,
respect of the-
renewal of the trade license.
This
Renewal of the trade license.
other matter, renewal of
But
the
is there any order for the verification or the, which is, I mean, alleged to be have been forced?
for
That is
my-
not there, only the
my lord.
part is that is the trade license, whether the trade license can be issued or not. That part is to be verified.
Yes, my lord, that is that part, my lord.
But
in-
your this petition here, the allegation is against you that you have forced the tenancy agreement. And on the basis of the forced agreement, you have obtained the trade license. That is the case.
No, this is that is their allegation.
Yes, yes, their allegation.
Their allegation, but in the lordship, your lordship, while the disposal of this writ petition, in paragraph 2, it is said that on the complaint, And my lord, he is also stated in the present affair regarding that particular
But
complaint.
they use it. Heard Mr. You're Mr. D.
Burwa.
D. Burwa. Heard Mr. D. Burwa, the learned counsel for the petitioner. Also heard MS Antas, the learned additional PP appearing on behalf of state respondent. What to file whistle and more.
I have no idea. my lord.
Respondent.
I have no.
Respondent, so and so. This is an application under section so and so in connection with so and so. Next, it is submitted by Mr. Borwa, the learned petitioner PP, learned counsel for the petitioner. That the present accused petitioners are. You are for now one for one, no?
For one, my lord, another is already been.
No, for you are for now?
Gajanan Munda.
Gajana, or the petitioner is innocent and has not committed any such offense as alleged in the FIR. It is a fact that there was a tenancy agreement between the informant and the present petitioner along with one who accused, and on the basis of which they have also obtained the trade license, which were also renewed in 2-3 occasions. However, subsequently the renewal of the trade license was refused by the authority concerned on the basis of complaint made by the present informant. One of the co-accused was arrested in connection with this case, which was granted bail by the learned CGM on the day of his arrest. Mr. Borwa further submitted that the present petitioner is, however, ready and willing to cooperate with the IO in further investigation of this case if he is granted with some interim protection. Mr. Borwa further submitted that one writ petition was also filed, wherein the coordinate bench of this court had passed the order for verification and to dispose of the matter in regards to issuance of in regards to the renewal of the trade license. MS does the learned additional submitted in this regard that there is the allegation of forgery, and as per the allegation, the petitioner along with the other co-accused person had forged the tenancy agreement on the basis of which they obtained the trade license. Accordingly, she insisted to call for a case diary. Considering the submission made by Counsel Gokul says other aspects of the case, and also considering the order passed by coordinate bench of this court in a writ petition, this court is of opinion that the petitioner may be given a chance to appear before the IO and to extend his cooperation in that regard. In view of this, he is provided with swears. He will be under interim. When can be fixed? On date?
8-9 Lordship.
Pardon?
8-9.
8-9. September 8-9. You appear before the IO within 10 days and cooperate in the investigation.
Mass objection.
Made submission a bit simpler because otherwise you have made severe submission. I could not follow in fact. কিয় বিচাৰিছে আমিতো সেইটো অৰ্ডাৰ কৰিব খোজা নাছিলো কিন্তু মেনশ্যন কৰিছে মই লিষ্ট কৰিব ৰেজিষ্ট্ৰিত যাব মই অৰ্ডাৰ নকৰোঁ মইতো চবি নকৰোঁ কেতিয়াবা কি হয় দেয়াৰ আৰ চাম নাম্বাৰছ যে সাপোজ 15 পৰা 28 মোৰ তাত প্লেচ কৰিব তেতিয়া ইন দোজ মেটাৰ্ছ আই এম ফাৰ্ষ্ট দি অৰ্ডাৰ বাট দোজ আৰ নট পুট আপ বিফৰ মি না মেনশ্যন হে ক'ব দিছে যে আৰ্জেণ্ট মেটাৰ আছে নাই ঘূৰাই দিব এইবিলাক চব and they asked them to approach before registry.
Supplementary item. Motion with item 62.
Made P.J. Lordship. Here, my lord, a report was sought for, my lord, whether any case has been registered against me in the Dispool police station or not, my lord.
My lord, here, my lord, we received one report, my lord, from the Dispool police station. My lord. As per the report, my lord, there is no case registered against the person.
But my lord,
My lord, in the earlier, my lord, order, when my lord was pleased to pass the order, my lord asks another thing also, my lord, whether the organization, my lord, that organization filed any FIR or not. My lord. That was also part of that. But that report is not here, my lord. My lord, can we, my lord, take that report also, because maybe they don't understand, because our word was.
But my lord, but there is, whether any case is against me or not, my lord, in that police station.
No case, my lord. That is very clear, my lord. With due respect, I have the honor to report that there is no any case registered against Moinuddin Ali at Dispur PS till date, my lord. So that was the report, my lord.
But my lord, my apprehension, page 3, my lord, my lord, page 3, paragraph 3 and 5. That may be recorded, my lord, and lordship may dispose it of, my lord. Page 3, paragraph 3 and 5. That they also have shown, my lord. I have made one statement, my lord. And against that statement, there was a, my lord, in the property time, my lord. Because,
This statement was made by you.
my lord, it was made by me admittedly, my lord, and paragraph 5, my lord. And paragraph 5 and page 8 is the, my lord, screenshot of protein time, my lord.
Paragraph?
Paragraph 5, my lord, I have written my apprehension. And to support that apprehension, my lord, I've given one, annexed one screenshot, that is page 8, my lord.
Page 8.
Page 8.
No, page 8 is not there.
Page 8, no, page 8 too.
Acha, FIR log, acha, that is the.
That is the apprehension, that, my lord,
সম্মিলিত yoga মঞ্চ।
no, all Assam, 1 minute yoga monster, my lord. So that is my apprehension, my lord. For that, my lord, I'm before your lordship, my lord. If they have said there is no case, lordship may dispose it of, my lord. Recording my submission and my apprehension, my lord. Arrest is not required, my lord. That may be, but there is no case, my lord.
Because till today, my lord, there is no case pending, my lord. But my lord, tomorrow, if there is somebody will.
Till today, my lord.
Because, my lord, this is, they have sent it on 22/7/2025, my lord, the report, my lord. As per that communication, my lord, no case is pending. That may be, my lord, kept as a part of the record, my lord.
Heard Mr. S.M. Abdullah P, the learned counsel for the petition, and also heard Mr. K. Bosha, the learned additional PP, appearing on behalf of state respondent. Now, this is an application. Just a second. Will be assigned. Under section 482 BNSS. Paying for pre-arrest bail in any probable case being registered under the Dispur police station. Mr. Bosha, the learned additional PP, submitted in this report. That report has already been received from the officer in charge, Dispur police station, whereby it is reported that till date, there is no case has been registered against the present petitioner in Dispur PS. Next para, Mr. Abdullah, that it's submitted in this report that he has the apprehension of filing of any FIR or registration of any case against him, as due to the statement made by him, which is reflected in the para 3 of the petition, and in the same time the in para 8 of the annexure 1, the para 8.
The page 8, my lord.
Page 8, annexure 1 is the
apprehension is paragraph 5.
A relevant portion of the news which has been which was
My lord, screenshot of a news, my lord, that is, I think, my lord, telecasted by Protein
Protein
Time.
Time.
The name was
this
reflected as like.
this can also an exist screenshot of a news which was published in Protein Time.
Protein Time.
Protein Time.
Telecast.
Oh, this is the.
It is just a photo, my lord, of the when my lord news was telecasted, what I understand is.
Yes, yes.
Satellite television.
With the news channel.
The person he is not the person.
But he is the person, man. Against him, they have said that.
But my lord, there is no, my lord, FIR, my lord. There is no FIR as per the report.
But did it? No, I'm
That is a news, my lord. Sometimes, my lord, in the report of a my lord, reporter, that may
This
be wrong.
the
my lord.
news, he had the.
News item, my lord.
News item,
News
he had
item.
the apprehension.
Yes,
Yes,
my lord.
madam. That is what I am submitting.
So and so. But from the report of the IO, it is seen that till date there is no registration of this case against the present petitioner. However, the petitioner will be at liberty to approach this court.
Yes.
And if any such case of the FIR is lodged against the present petitioner. But till date, this court is of opinion, there is no need of any order of, there is no need of any privilege of pre-arrest to the present petitioner at this case. With the above observation, the petition stands disposed of, and the report received from the officer in charge
Part.
Dispur police station may be a part of the record.
But,
Obliged.
It is motion. Item 22.
In this case,
You are appearing for as a government advocate?
Yes, Your Lordship.
FIR is phase
FIR is on page
15, 1 The minor daughter of the petitioner has been kidnapped by the respondent number 6, the accused person. And till today, the police has not traced out the victim girl.
Could not trace out.
Could not trace. Thereafter, several occasions the petitioner approached the police, subsequently filed a representation before the superintendent of police, Hosai. But nothing has been done.
What is your, what do you have any other instructions?
Your Lordship, we will need instruction, Your Lordship. Time may be granted, please bring the instruction.
Your minor daughter is missing since when?
Which is since 17/5/2025.
17/5.
17/5.
So you are now representing one.
1, 2, 3. Your Lordship, the numbering is not correct. Your Lordship, number 4 is missing. Actually, it should be 1,
3, 4 and 5.
4 and 5.
Representing 1, 2, 3, 4 and 5 and
6 is private, Your Lordship.
6 is private. He is OC in charge.
This is the accused person.
Accused person.
Oh, achha, he is the accused person. Why Prag is not?
This is IO.
Achha, Vikas Chauhan is the hearing.
Because one is the accused person.
Pragjot is not, he is SI.
IO of the case.
So these two you are not going to represent. right?
Yes, Your Lordship. 1, 2, 3, and 4, Your Lordship.
You are Mr. A. Rahman.
MZ Shah.
M?
MZ Shah.
Oh, sorry. MZ Shah. Heard Mr. MZ Shah, the learned counsel for the petition, and also heard MS.
R. Gogol.
R. Gogol. Government advocate, representing the respondent number 1, 2, 3, and 4. In fact, 1, 2, 3, and 4 hoga 1, 2, 3, and 4. This is an application under Article 226 of the Constitution of India for issuance of a written nature of habeas corpus or mandamus, certiorari, or any other appropriate writ, alleging that no action has been taken by the officer in charge, Lanka Police Station, for recovery of the minor daughter of the present petitioner. who was reported to be in the custody of the accused oblique the respondent number 6. Mr. Okay, MS Gogoi. Na? Oh, sorry, MS Gogoi submitted in this regard. The law enforcement advocate submitted in this regard that she will take proper instructions in that regard as to whether any action has been taken against the accused who allegedly kidnapped the minor daughter of the petitioner. Next, issue notice to all the respondents. No formal notice is required to be served on respondent number 1, 2, 3, and 4. And as the respondents have already represented by through the learned environment advocate, however, no issue notice may be issued to the respondent number 6 and 7 to register post and as usual process. Leads the matter according when your instruction as
2 weeks time may be granted.
2 weeks. Leads the matter accordingly 2 weeks, enabling the respondents to take instructions in regards to the present case. List accordingly.
So 2 weeks.
2 weeks, yes.
Bail hearing BA, item number 23.
Maybe the lordship. Can you now identify the numbers? Numbers below. Kun number, kun case. You will be able to identify? Yes.
Lordship 483 bail application, Lordship. 3 persons were, the FIR is page at page number 13, Lordship. 3 persons were arrested, Lordship, for carrying contraband, Lordship. And however, Lordship, I'm not on merit, Lordship. I'm on procedural requirement, Lordship. Section 47 was not complied, Lordship. Therefore, your Lordship granted bail to the other 2 prime accused, Lordship. I'm the 3rd one, Lordship. And my role was, Lordship, I was hired driver only, Lordship. Order is page number 30, Lordship. 30.
Otherwise, you are in custody since?
Since, Lordship, 1/11/2024. It's 9 months, Lordship.
Charge sheet has already been laid.
Yes,
Charge framed or not yet framed?
not yet, Lordship. We are facing other 2 accused are facing trial, and I am also, Lordship, from the custody.
The other 2 accused persons are now not appearing.
No, they are appearing, regularly appearing, Lordship.
Appearing?
Yes.
So you are the driver.
I was hired driver, Lordship. Even police admitted it also in the FIR also. Both the prime accused, Lordship, Career and Honor, both they were granted bail, Lordship.
Yes.
Yes. My lord, here, my lord, arrest on my lord 31/10/2024, my lord. The present accused petitioner was
31? He is saying 1/11/2022.
1/11 or 31 10.
1. FIR is a page number.
My lord.
Anyway, 31/10 and most probably
Only
probably before 1.
So, my lord, here, my lord, the present accused petitioner, he is one Shahjahan Ali, my lord, who was, my lord, in the affair, we found that, my lord, this is Shahjahan Ali was driving while Rose Ali was the co-driver, the another accused person, my lord, who was already granted bail by this honorable court, my lord, on 14/5/2029. That is annexed. And my lord, here, it is on the ground of arrest, so I am not taking so much precious time of this honorable court, my lord. I have gone through the record, my lord. there are, my lord, 47 and 48 notices are there. But my lord, as per what is stated in the Bihan Kumar, my lord, as per the written communication, that is not there, my lord. That part was, I didn't get, my lord. My lord, now next part is that after Bihan Kumar, my lord is very much aware because I have gone through the earlier, my lord, order, that is the where the co-accused was granted bail. My learned colleague was appeared in that case, my lord. And both the matters, my lord, they are on the same footing, my lord, both the accused person, because from their conscious position, that was, my lord, contraband were recovered, my lord. Where, my lord, my learned colleague also submitted one thing, my lord, though, my lord, the case law was not submitted, my lord, at that point of time, that, my lord, his contention was that, my lord, may I read, my lord, that part only. That, my lord, his my lord, contention was that, my lord, that is, though, my lord, in the, my lord, 47 and 48 notice, my lord, that is in the written form, that is the grounds of arrest were not, my lord, there, my lord. But he was informed, my lord. He was told, because, my lord, he was caught red-handed, my lord, from the, my lord, but that is the vehicle itself, from where, my lord, that is contrabands were recovered, my lord. That was told. My lord, after Bihan Kumar, my lord, one, my lord, I will provide, my lord, that, my lord, that is particular, my lord, there also, Honorable Supreme Court in Kasi Reddy Upendra Reddy, my lord. My lord was very much away. And 2 points, my lord, that is, Supreme Court here, it is a warrant, my lord, then this matter will not come into play. If it is not from the warrant, my lord, the police arrested, my lord, then, my lord, word is used there as a tool, my lord, and informant. And obviously, my lord, there, if it is also inform or told, my lord, that part we have to look out, look into the matter, the whether such kind of, my lord, that is regarding that communication is there or not. But, my lord, in the said matter, my lord, I didn't get with, my lord, entire CD, my lord, where, my lord, that note I didn't give. But other than that, my lord, written communication was not there. So, my lord, in the, my lord, that is Kasi Reddy's case, my lord, in para 36, my lord, it was stated that, my lord, if he is arrested without a warrant, he must be told why he has been arrested. The word was, my lord, used as told, my lord. If he is arrested for committing an offense, he must be told that he has committed a certain offense for which he would be placed on trial. In order to inform him that he has committed a certain offense, he must be told of the acts done by him which amounts to the offense. He must be informed of the precise acts done by him for which he would be tried. Informing him merely of the law applicable to such acts would not be enough. So that was, my lord, the Kasi Reddy, my lord. Word is not regarding the written communication is used, but obviously, my lord, that is the precisely he has to be informed that for which he was arrested. So that is my submission. Otherwise, my lord, that is race part is, my lord, similar to that earlier order, my lord, because that is also co-accused was the co-driver. Though, my lord, it was driven by the present petitioner, 14/5/2025. That is my humble submission before your lordship. Otherwise, my lord, contraband recovered from the conscious possession, my lord. And, my lord, that is the regarding the part of prolonged incarceration also, that will not come into play, my lord, at this stage, my lord.
Lordship, regarding Kasi Reddy Lordship, even I have the judgment Lordship, that in Kasi Reddy Lordship, the case was all about a warrant Lordship. And if we go for this warrant Lordship under section 70 of CRPC Lordship, then Lordship, warrant is when law enforcement officers someone into custody based on a warrant issued by court. So here in this case, Lordship, it was police only who apprehended them in front of the police station, Lordship. And regarding the, as he has mentioned, Lordship, I'm on same footing. In that regard also, Lordship, Apex Court judgment on criminal appeal number 477 of 2017, Lordship, Yugarani, Lordship. In Yugarani versus the State of Inspector of Police, para 10, Lordship, married, Lordship. In that para, Lordship, just 2 lines.
You're going to supply this one?
Yes, yes, Lord. In that para 10 lordship, the court cannot convict one accused and acquit the other when there is similar or identical evidence pitted against two accused persons.
That is on the
So
trial.
lordship, it's clearly seen here, lordship, that we are on same footing, lordship. In fact, I was the driver, hired driver. So lordship, and regarding lordship, Vihan Kumar, in Vihan Kumar lordship, the only thing is that lordship, that grounds of arrest lordship must be supplied in written form, lordship. Verbal communication is not appreciated, lordship. So that is my humble submission, lordship.
Okay.
I am also allowed to, my lord, summarize this, my lord. I have mentioned the relevant paragraph, my lord.
In fact, in Kasireddy Upender Reddy case was, lordship, based on warrant, only on warrant,
My
lordship.
lord, in that
Yes.
case, my lord, para 36, my lord, two things are there. First part is regarding warrant. Next part is the next line, my lord, that is if without warrant. That part. Warrant is very clear, my lord. In that part, my lord, it is not required. But obviously, my lord, in 36, it is very clearly they have stated if it is also told or informed, that must be precisely. Here in the case, that is the accused petitioner was caught red-handed, my lord, from that, my lord, the vehicle from where the contraband.
This was the thing actually, lordship, which was reiterated so many times, lordship. The whether verbal communication is appreciated or not, lordship. That was the case even in Pankaj Bansal, Vihan Kumar, wherein earlier lots of orders and judgments are there, lordship. That is the thing only. Also, when violation under Article 22 is there, lordship, then these things will not, lordship, render, lordship.
The basis of which now you're saying that he was told,
My lord.
and that is to be. Now, obviously, that another aspect is there that he was may not be from his conscious person, but he was there and then when the arrest was made, along with the contraband.
Yes.
That is there.
Yes.
But yes, obviously, Kashireddy next part is without warrant.
Precisely,
That part is there. Precisely should be informed, and then
that must be precisely. Not only we have to say about the regarding the offense, but my lord, that is that precisely informed. That part is there.
Principle of parity will also principle of parity will also apply, lordship, because I'm on same footing. Moreover, this lordship, I was hired driver. That is admitted fact, lordship. So that part will come, lordship.
we passed you.
Lordship, other two accused, empire is all about that prime accused, that accused number one, lordship. He was the owner, he was the supplier, everything. Then he hired one carrier who was in my car, lordship. He hired the car. Even in statement, lordship, I have read that at rupees 10,000 he hired the car. So lordship, I'm a professional driver. He hired my car. I was in the car. So lordship, what was in their bag? I cannot check my passengers, lordship. But that was my part, lordship. And lordship, hearing all these aspects, lordship passed order, lordship, and granted bail both the accused, lordship, in view of Vihan Kumar and Prabir Prakash, lordship. Highly obliged, lordship.
May please, your lordship. It's a regular bail application. I'm in custody for 132 days, my lord. The allegations is attempt to murder and causing grievous hurt, my lord, by means of a sharp weapon. Now the investigation is over, my lord. Charge sheet has been submitted. Case has already been committed, my lord. And today is the date fixed for framing consideration of charge before the learned court of sessions, my lord. Trial court, my lord. These are the facts, my lord. Now, my lordship will kindly come to the FIR, my lord, which your lordship will find at page 9. May I read, my lord? The humble petitioner most respectfully begs to state that my brother, so and so ages so and so, on today evening at around 7 p.m., he has been going to Difu Fish Market to buy fish from the shop of Muhammad Nazirul Islam. This is the petitioner, my lord. At the time of purchasing, the accused person, Nazirul Islam, had used to misbehave on victim Sukur Singh Inki. Then after that, he beating, this is a verbatim translation, so English is, my lord, everywhere, going everywhere, that he beating badly to victim person. Also, finally, the accused person has intended to murder the victim so-and-so, which has been attacked with sharp weapon and thou on him, severe injuries on the right side of face and cutting injury on his neck and body also. Presently, he has been admitted to ICU at Difu Medical Hospital. Well, I've gone through the records, my lord. The medical report is also substantiating this allegation that the victim had sustained grievous injuries on his neck. So that is something that we are not disputing. Even in our petition also, which we filed before submission of charge sheet, we had not denied this altercation which took place. This petitioner, admittedly, my lord, he is a fish vendor, my lord. In the fish market, he was selling fish, and on the date of the incident, the victim had gone to his fish market. Some sort of a quarrel took place, my lord, and during the course of the quarrel, this petitioner had allegedly hit him on his neck with a dao, with which he was cutting the fish, my lord, and then the victim sustained injury. So all of these have come out in the investigation. So on that point, my lord, there is no point at this stage, my lord, disputing all of this. Those will come out in trial, man, whether this was provoked or not provoked. My only humble submission before your lordship is that since already the case is fixed for consideration of charge today and trial is about to commence, my lord, I'm already in custody in 132 days. Victim has already recovered because his statement has also been recorded under 183, my lord. So whether perhaps further detention may not be necessary. Subject to what my learned friend says, my lord, that perhaps this is not a case where he requires to be kept in custody for the length of the trial. Already he has spent 132 days, my lord. Well, let him face the trial. If it's proved, my lord, he will be punished for it.
Yes, my lord, already my learned friend has stated, my lord, that is the injury is, my lord, previous, my lord. Police collect, my lord, sees some other items, that dowry is also, my lord, that is also seized, my lord. And also, my lord, DNA report that was, my lord, sent, my lord. Then from the blood stain there, my lord, it's come to know that, my lord, from the FSL report, that is the, my lord, victim, which is used, my lord. So these are the part of my lord trial. Now, my lord, today is already being committed and today it is fixed for consideration of charge. So if, my lord, my lord, it is very, my lord, initial stage, my lord. And my lord, in the FIR, my lord, if my lord notice one thing, my lord, that that is the FIR, it is stated that, my lord, my lord, after committing the offense, he immediately ran away. That was the thing, my lord. And my lord, independent witnesses are also there, my lord. There, my lord, 183 statements are there. So, my lord, my humble prayer before your lordship is that not at this stage, my lord, because, my lord, today is the date for consideration of charge, my lord. At least, my lord, those independent witnesses, because, my lord, the person who, my lord, within the, my lord, that is the marketplace, who can immediately cut a person, my lord, by using a jaw, my lord. At least, my lord, those independent witnesses, those are also, my lord, vendors, my lord, the nearby vendors, known to the person very well. So let them at least, my lord, examine that.
That will result in the conclusion of the trial. And regarding
there are some independent witnesses, my lord. So they are yet not, my lord, whether it will be, my lord, today is the date for getting on charge, my lord. We don't know what will be the outcome of that, my lord.
This person was arrested on the date of the incident. So obviously, when the incident has happened and police has nabbed him on that very day. This is not a case where police have to go in search of him and then arrest him. So he was arrested on the date of the incident. Now, whatever materials are there, my lord, I don't see this a case for discharge. The charges will definitely be framed. This person is not a local resident of that place. The witnesses whose statements have been recorded, they are all local residents of that place, my lord. And in fact, we have put this on record also, my lord. Following this, because these belong to different communities, this whole incident has also taken a communal color there. For a result of which, my lord, this person could not even engage a lawyer there. Those are subsequent issues. I'm just pointing it out, my lord. Now, legal aid counsel is defending him. If your lordship imposes strict conditions that he will not leave the jurisdiction, question of influencing will not arise, because from whatever I've seen in the charge sheet, these people who are cited as witnesses.
But the other witnesses which he have submitted,
yes,
the independent witnesses, they are the vendors also.
They are also, my lord, residents of that area, and this person, my lord, he was also beaten up. So that is also there on record. The victim, the petitioner has also sustained injury. This has come on record. It is there. So he was, after this incident, he was also beaten up. The vendors and all of the persons, if your lordship sees the records, they are all residents of that place and they belong to the same community of the victim, my lord. So this person is not in a position to influence those witnesses. My only submission, my lord, is that this is perhaps not a case where he requires, unlike an NDPS or a POCSO case, not a case where he requires to be kept in custody for the length of the trials. Charges will be framed, my lord. All the witnesses are local residents of that area. He has no sway or influence over them, my lord. If your lordship allows him to go on the strict conditions, my lord, that he will not leave the jurisdiction, any other condition may be imposed, my lord, he will face the trial, my lord. On these facts, my lord, this is the best submission I can make, my lord, because admittedly, materials are there. Those I am not, cannot dispute at this stage. Only trial will reveal the circumstances in which this incident occurred. My lord.
Those witness I have already flagged my lord. Other witnesses are also there. Two witnesses I have.
Those are there.
And also, my lord, the statement of the victim also.
So this is the admitted that he sustained grievous injury and the injuries were sustained grievous in nature, and that is admitted by Mr. Nawaz also. Then the question is that whether the further custodial, that is the only issue.
Because, my lord, because of the my lord, nature of the offense, only that my submission is that, my lord, that obviously, my lord, there is a right of every person, my lord. On that point, my lord, I am agreeable with my learned friend. Only, my lord, suspicion is that because they are the vendors, my lord. They are the vendors, independent witnesses are there, not only the victim. That's
in these circumstances, it is unlikely to even go, not even possible for him to go to the fish market because of the aftermath of the Soon incident.
Heard Mr. S. Nawaz, Learned counsel for the petitioner. I also heard Mr. K. Bushra, Learned additional PP, appearing on behalf of state respondent. This is an application in the section so and so in connection with so and so. Scanned copy of the TCR has already been received. Where is received? It is submitted by Mr. Nawaz that the present is that it is an admitted fact that there was a quarrel took place between the present petitioner and the victim while he was purchasing meat, fish from the from the petitioner. However, the petitioner is in custody since last 132 days. 32 days since his day of arrest, and case has already been charge sheeted. And today was the date fixed for framing of charge. Mr. Nawaz further submitted that it is also not disputed that the victim sustained grievous injuries on his neck, and due to injuries on his neck, but injuries on his neck. But to Fustafari, he submitted there cannot be any question of hampering or tampering with the other witnesses, as the present petitioner is not the local resident of he is not the resident of that locality wherein the incident had happened. However, he will contest the case by regularly appearing before the learned trial court below, as and when the date is fixed by the court. Next one, Mr. Bushra, the learned additional PP submitted in this regard that today was the date fixed for consideration of charge, and trial is about to be commenced. But from the injury report of the victim and other circumstances, it is seen that the victim sustained severe injuries, and there was an attempt even to commit murder of the murder of the victim. He further submitted that there are, apart from the victim, there are several independent witnesses who witnessed the occurrence, and being the co-vendor of the fish market, there is every probability of influencing the evidence of those independent witnesses who are yet to be examined by the court. Mr. Bushra accordingly raised objection and submitted that till the evidence of the said independent witnesses, the present petition for bail may not be considered, as the probability of influencing those witnesses cannot be denied at this stage. Next, considering this submission made by learned counsel for the court says brevity of the offense and other aspects of the matter, it is seen that the probability, the submission made by the learned additional PP regarding the probability of influencing the independent witnesses who are also the co-vendor in the same fish market. I find that you cannot no, কি দিছে? কি দিলে আপনি? Cannot be denied at this stage. Baki indicators cannot be denied at this stage, and accordingly, I don't find it proper to allow the bail, allow the privilege of bail to the present petitioner at this stage. In this witness observation, the bail petition stands disposed. Okay, your bail petition rejected.
Get liberty to apply afresh after the examination of the independent witnesses.
Okay, the petitioner will be at liberty to file file a bail application afresh. Will go to them. Bail application afresh. Baki nahi line ka
Deep level.
25.
Meet the lordship office. This is a bail application, and lordship may kindly peruse the FIR at page 90 days.
Days?
Today, 90th day, your lordship.
90th day.
Yeah, 90th day.
Oh. He has brought for any probability, no charge sheet.
Only on the ground of length of.
Yes, lordship.
Mr. T. Dewey, the learned counsel for the petition. And also heard Mr. P. Waterford, the learned additional VP appearing on behalf of the respondent. It is submitted by Mr. Dewey, the present accused petitioner. How many petitioners are here?
Only one.
He is innocent. Has not committed any such offense alleging the FIR. However, the present accused petitioner was arrested 25/4/2025, and till date he had already the statutory period of 90 days is already over today. However, the petitioner is ready and willing to cooperate in the investigation of this case if he is granted with the privilege of bail. Next para, Mr. Waterford, the learned additional PP submitted that there are sufficient incriminating materials against the present accused petition. However, the IO could not file the charge sheet even after the lapse of 90 days, 90 days posted. In view of this, without going any detail of the merit of the case, only considering the length of detention, the present petitioner is allowed to go on bail to the satisfaction of various cases.
Even Biswanath.
Vishwanath, your lordship. CJM
Biswanath.
Vishwanath.
Satisfaction of CGM Biswanath, comma Biswanath Chariali. Practically condition DD. 20,000 per year level wage considered. Okay, will be under.
Very good. 26.
26 may be taken after some time, my senior is election code number 21. A series is going on like. That's something.
27.
This is a lottery competition case, my lord.
Notary competition.
My lord, one president of the club has lodged a complaint that some individual person has, by using their name, organized a lottery competition. And subsequently, they uploaded it through the Facebook, my lord. And according to the petitioner, he was arrested on 36, my lord. Page 10 is the affair. Rashikau Zubuk Club President, he lodged the affair. But operation has not committed. They had attempted to organize and sell the coupon and try to collect money from the public by uploading the gift coupon in the Facebook. I was arrested and I have been interrogated thoroughly, my lord.
Okay.
I consider
Yes,
land of
please, I
detention.
received, my lord. Otherwise, my lord, FIR is lost by the president of that youth club, my lord.
FIR is lost by?
Lost by president Rasigao.
Rasidagao Zubok Club.
Yes. Now, my lord, allegation is that what they have done, the present petitioner has done, my lord, by using the name of that club, my lord. He published, my lord, in the social media, my lord, Facebook and other social media, that that this club is organizing my lord, lottery my lord, competition.
Competition.
And on that basis, my lord, they have also provided, my lord, some phone numbers in that advertisement, my lord. And thereafter, one, my lord, my lord,
QR code is also
QR code was also, my lord, provided, and in that manner, my lord, they are collecting money from, my lord, various persons, my lord, that is the allegation. And present petitioner is, my lord, directly involved, my lord. He, in fact, my lord, police has seized the phone number of the, my lord.
My phone number is there.
And
My-
from
my
his
phone
phone
number is
number, as per note of the IO, some of the, my lord, lottery tickets were also, my lord, found in his.
Not sale, my lord, but try to collect. Before that, the
Money is already,
That
they
is-
sold some tickets or not,
No,
could
not
not,
sell.
could not sell?
Not sell.
Those tickets are not in the case diary, my lord.
No, could not sell the ticket or some of the tickets were
No,
sold.
sir.
As per his statement, মই আৰু আজিবুৰ ৰহমান প্ৰায় 6 মাহ মানৰ পৰা লটাৰী টিকেট বিক্ৰী কৰি আহিছো। আমি হোৱাটছআপৰ দ্বাৰা টিকেট বিক্ৰী কৰো আৰু মোৰ লগত জিপে QR, so they also, my lord, in that advertisement QR code was also provided. And from that, my lord, regarding that, my lord, whether from his statement he has stated that for last 6 months he has collected money by way of selling those tickets.
He was arrested on 36 and statement has been recorded. So by considering the length of detention and his prior custodial detention is, I fully cooperate with the my lord.
And regarding the involvement of any other person.
Otherwise, regarding those phone numbers, my lord, which were mentioned in the FIR, my lord, those persons who, in whose name those, my lord, mobiles, my lord, name of those persons are not specifically mentioned in the, my lord, case diary, my lord. Who are those persons? That their name, police has also not, till now, IO has not collected the names of those persons in whose name those mobile numbers are there. My lord. Otherwise, my lord, one mobile phone of the present petitioner
My
was
phone I adjust.
seized
My
by
phone-
the police, and in his mobile number, my lord, some of the lottery tickets is also there, my lord, that is mentioned in the note. Investigation is going on, my lord.
On 36 he was arrested and he was thoroughly interrogated. He cooperated with the IO, my lord.
One Adizur Rahman, who is a co-accused, my lord, not yet arrested.
Not yet arrested. Heard Mr. J. Ahmed, the learned counsel for the petitioner, and also heard Mr. P. Waterford, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. It is submitted, CD received, is received. Next, para, it is submitted by Mr. Ahmed, the learned counsel for the petitioner, that the present petitioner. So you are not saying that you did not. You are not saying that you are innocent. That is not.
But he, I cannot say, but he stated before the IO. So he is fair, madam.
Submitted that the accused petitioner got arrested in connection with this case on 30/06/2025, and since then he is in custody full stop. The Ayog got the opportunity to interrogate the present petitioner thoroughly, keeping him in custody. And hence further custodial interrogation of the present petitioner may not be required for the interest of the investigation. However, he admitted that the mobile number which was mentioned in the FIR belongs to him, but there was no money was misappropriated through that advertisement. Through that the Facebook post, no, it was it?
No.
It was a Facebook post.
Facebook advertisement.
Next paragraph. If the petitioner is still ready and willing to extend his cooperation in the further investigation of this case, if he is granted with the privilege of bail. Next paragraph, Mr. Botapu, the learned additional BP submitted in this regards that the present accused petitioner is fully involved in the alleged offense, and his mobile number is also tally with a mobile number, and the mobile number is on and he used his mobile number to commit the offense by organizing in the lottery competition in the name of
Rashigao Jubo Club.
one in the name of one Rashigao Jubo Club, and even provided the QR code. Some of the co-accused persons are yet to be arrested in connection with this case, and the investigation is still under process. Mr. Botapu accordingly raised objection and submitted that the accused petitioner may not be released on bail at this stage. Next paragraph. Considering the submission made by learned counsel for both sides, I have also perused the case diary, and considering the case diary, we have seen that the IO has collected some materials against the present petitioner, and but without going in detail into the merit of the case, only considering the length of detention undergone by the accused petitioner, I find it effective to extend the privilege of bail to the present accused petitioner. It is a case of which place?
Bongaigaon.
Bongaigaon. The satisfaction of CGM Bongaigaon. Okay, we will continue.
Hello, listeners.
Supplementary was this hearing here, I think number 63.
Wait, please, your lordship. Today is the matter 90th day, my lord. Petitioner was arrested on 26, my lord, for 2025, my lord.
2006.
26.
26.
26. Today is the 90th day, my lord. If your lordship calculate, my lord, April 5 days, May 31 days, June 30 days, today is the 24th July, my lord. No charge sheet has been laid.
Not May, this is a month of June only. 26, isn't it?
No, 26/4, my lord.
Or 26/4.
Item number given? 63.
63.
Date of arrest, your lordship will get page 9, my lord.
Yes, today is 90 days. Botapu.
Yes, my lord, on earlier date, my lord, your lordship has fixed it today. Earlier on, we was earlier listed on about it. Yes.
Oh, that is the case now.
My lord. But this is, madam, 90 days offense, my lord. But no IT Act is involved in this case, my lord.
So we posted this case today, in fact, with a view that if charge
No,
sheet
my
is-
start sheet
should not
not yet.
come in.
Yes.
Otherwise, the nature of case is very.
Yes, yes.
We
My
have
lord,
on
they
that
have
day.
projected my otherwise, my lord. I have just replied to one message of one Probin Hazarika,
My
my lord.
lord, not projected otherwise, my lord. What is the reply, my lord? That reply is also I pointed out to your
Yes,
lordship, my
we
lord.
have that day, we have produced.
My lord, I have also seen the my lord message. It is not readable in open court, my lord.
Not
But
readable.
not readable, my lord. But my lord, this section which is imposed, my lord, that is not attracted, my lord. But I am not in the my lord made of the case, my lord. But
Today
it-
only
it-
on the
it-
ground of length of detention.
length of detention. To this 90 days, my lord, no such is there.
He will again make such kind of thing.
No, my lord. I will instruct my client. my
If such statement is made openly in the either Facebook or any account, what can we do?
My lord, inform my client, my lord. That offense will not repeat, my lord.
Your good name?
TK Bhuya,
TK Bhuya.
my lord.
Your name is not here, no?
Otherwise, he will be again in difficulty.
Hmm?
If you will not stop. this
Next, my
type
lord,
of
if my client, my lord,
activities,
does
he
this,
will
my
be
lord, I
again
will
in
never come
difficulty.
before your lordship. my lord.
These things are now happening, in fact, we are reading all these things.
Otherwise,
Especially after the Pahalgam incident, these kind of things are going on. Openly.
The misuse of my lord public fund, my lord.
Pardon?
Maybe public firm, but
My
now,
lord,
my lord,
misuse of public, my lord, platform, my lord.
now comes to light, my lord, how they are, my lord, acting against the nation, my lord, how this type of they can make, my lord. Otherwise, it is good that, my lord, those things comes out, my lord.
The remarks which has been made is really.
It is very bad, my lord. I admit, my lord.
Anyway, heard Mr. TK Bhuya, the learned counsel for the petition, and also heard Mr. P. Waterford, the learned additional BP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. CD already received, parents received. Heard both side. No, parents received. It is submitted by Mr. Bhuya, the learned counsel for the petitioner, that the petitioner got arrested in connection with this case on 26/4/2025, and today is the 98th day. But as per his instruction, the IO could not furnish the case charge sheet till date, and accordingly he submitted that considering his length of detention, the petitioner may be released on bail. However, he will extend his cooperation in further investigation of this case if the same is needed by the IO. Next, further, Mr. Waterford, the learned additional PP, submitted that the IO could not that there are sufficient incremental materials and some of the communal and provocating statement have been made by the present petitioner, but till date the IO could not furnish the case diary. Sorry, charge sheet. Next, considering the submission made by learned counsel for both sides, and without going detail into the merit of the case, only considering the length of detention, I find that the petitioner is allowed to go on bail to the satisfaction of
CGM Nogam.
CGM Nogam. So and so.
Okay, deeply appreciate.
I'm being item 26.
Sorry, my lord, I was in a different court, my lord. It's a regular bail application, my lord. Yeah, my lord, the offense attributed is, my lord, that 121(2). And in fact, possibly, my lord, 132 of the BNSS may be attracted, my lord, that assaulting a, my lord, that officer on duty, my lord, while discharging duty, my lord. And lordship was, case 19 is the FI, my lord. Both father and son were arrested, my lord. And on last occasion, lordship was pleased to grant bail to the father because allegation against him was that he instigated, my lord. And it was submitted by my learned colleague, my lord, that the injury, my lord, it was, my lord, Minor injuries, my lord. Allegation also punch, my lord. Some, my lord, father was humiliated, my lord. Some altercation was there, my lord. It is a fact, my lord. And 132 of the BNSS, my lord, that assault, my lord. That is, my lord, punishable for 2
But
years.
he
my
is
lord.
not the father, he is the son. who is the main
Father already
culprit.
granted, my lord.
No, I can remember.
Yes,
Father
yes,
was
yes.
granted only allegation that he
Yes,
was
yes, it's
insisting.
instigated. Now, my
But
lord,
the allegation against the present petitioner, he
he
is the son
assault, my lord.
assaulted.
And my lord, that kindly have a look at 132, my lord, that section, my lord. That is, my lord, assault or criminal force to deter public servant from discharge of his duty, my lord. That is extend to 2 years and fine or with both, my lord. Now, my lord,
And what about the other sections?
other that won't be attracted because that is grievous hurt only, my lord. That 121.
121, 2 is the grievous hurt.
Grievous hurt.
And 229?
That is, my lord, those all, my lord. Those won't be attracted, my lord, because 132 has been incorporated, my lord. 121 2 is voluntary, that is causing grievous, that is 10 years, my lord, and 121 1 is also hurt, my lord. When you cause hurt, it is one maximum is 5 years, my lord. But here, I have narrated everything in my petition, my lord. He should not have done it. No? Some altercation was there, and father was humiliated, my lord. Father was a retired, my lord, lecturer of a college. And my lord, he was presently in a school, he is working as a principal, my lord. 65 years, father was humiliated, mother also there. So my some heated exchanges were there. It is a fact, my lord, but possibly, my lord, that intention and my lord, that spur of the moment and maybe an offense under 132 and further detention may not be required, my lord. Master degree holder boy, my lord, and he's having some disability of his eyes also, and he was assaulted also, my lord. And possibly they will go for human.
320, they were called in the police station, I think.
Yes, yes, my lord. Because my lord, it was there was a now, my lord, that earlier 144, my lord. So, my lord, there was a my lord proceeding, but that is under 163 of the BNSS, my lord. My lord, and because of a boundary wall, my lord, and some dispute errors, my lord, they were trying to repair it, my lord.
Yeah, that is
Yes,
there.
and my lord, possibly, my lord, the police should not have. They have no power possibly not to interfere because proceeding is in a different, my lord, forum, my lord. They called, my lord. Some pressure possibly was there. Now, my lord, around 28, 29 days in custody, my lord. And this further detention may not be required. Any condition lordship may impose, my lord. Otherwise, my lord, injury report is there. Your lordship was pleased to, my lord, grant bail to the father of the petitioner, my lord, on earlier occasion. Regarding the, my lord, assault by the present petitioner, injury report is there, my lord. Simple injury. And yes, on that day, my lord, admittedly, my lord, the present petitioner assaulted the, my lord, officer in charge of the Nalbari police station.
Yes, but
Yes.
the situation was.
Yes, I would like to point out, my lord. Yes, admittedly, my lord, all those are some materials as CCTV footage, everything is there, my lord, admitted. And from the FIR, my lord, one admitted fact is also that, my lord, today morning, the first party, Sri Vijay Kumar Jain, met the superintendent of police Nalbari and informed that the second party violated the honorable court's order. So during that, all these, one civil case is also pending, my lord. So without informing that violation of the civil court's order, regarding those disputes are there.
But whether on that the violation of the court's order, suppose if there is any.
Yes.
So police
Police, my lord,
has the authority.
Actually, my lord, at that point of time, this, my lord, informant should have to immediately inform about the violation of the civil court order to the civil court, my lord.
Yes, yes.
By
always.
filing, my lord, application, my lord. But without taking that recourse, immediately, my lord,
Directly.
he approached to the police station and thereafter, regarding the present incident, admittedly, my lord, here's the present petitioner has committed the offense while, my lord, doing all these happens. These are all
Exactly.
admitted facts. An admitted fact is also that, my lord, this, my lord, civil dispute is pending.
Yes.
And because of that civil dispute, my lord, police intervene and, my lord, thereafter lodging of the letter, all these things is also. Family, my lord. Father is also lecturer. He was a lecturer he was also in defense thereafter in principal of a college now, junior college. He was humiliated, my lord. He should not have done it, but lordship at that moment possibly, my lord.
heard Mr. A. Chaudhary, the learned counsel for the petition, and also heard Mr. P. Bottakul, the learned additional PP, appearing on behalf of state respondent. This is an application and second reference in connection with students. The CD receipt, where is the same? It is submitted by Mr. Chaudhary that the present accused petitioner was arrested in connection with this case on 26/6/2025. And since last 28-29 days, he is in custody. He further submitted that
Earlier 353, my lord, now it is that 132, my lord, BNS.
এইটো মই এটা অৰ্ডাৰ কৰিছিলোঁ ইয়াতে অকণ ডিটেইলটো দিয়া আছিলে চ' ফ্ৰম এইখিনি নামকেইটা সলাই পেলাই এইখিনিকে আপুনি দিব পাৰিব এইখিনিৰ পৰা এইখিনিৰ পৰা মই লিখি দিওঁ খালি এইখিনিৰ পৰা দি আছোঁ He further submitted that further submitted that at the time of their appearance before the officer in charge Nalbari police station, it is alleged that due to instigation of the father of the present petitioner, he assaulted the police officer. And Mr. Chaudhary further submitted that it is the fact that when they appeared before the police station, the police officer had humiliated the father of the present petitioner, who is a college teacher. And in that altercation, at the heat of the moment, he might have assaulted the police officer, but there was no such intention to assault the present petitioner, the police officer, and only out of the provocation and at the spur of the moment that had happened. But though the case is registered under section 329(4) to 121(2), 132, and 3 subsection 5 of BNSS, except 132, the other sections are also not attracted against the present petitioner. He further submitted that the police officer did not sustain any such injury of any grievous injuries on his person full stop. More so, considering the length of detention already undergone by the accused petitioner, he may be released on bail. Full stop. However, he will extend his cooperation in the further investigation of this case. Next, Mr. Bottakul, the learned additional PP, submitted in this regard that admittedly the present accused petitioner had assaulted the police officer while he was discharging his duty, and discharging his duty in the police station, inside the police station itself. Stop. However, he submitted that as per the injury report, the victim sustained minor injuries on his person. Do you saying that CCTV footage was there, no?
Yes, sir. That CCTV footage, my lord, police has already, my lord, collected that footage of the CCTV and seized, my lord, and 65B certificate is also there during trial, my lord, that will.
And he submitted that everything has been also recorded under the CCTV footage, which has already been collected by the investigating officer.
Witnesses also implicated.
Pardon?
Witnesses also implicated.
And some of the witnesses also implicated the present petitioner. Next, madam. Considering the entire facts and circumstances of this case, from a submission made by the learned counsel for the petitioner, vis-a-vis considering the materials available in the case diary and the medical report of the victim, I find that further custodial interrogation may not be necessary, for the purpose of investigation. In view of this, I find it a fit case to extend the privilege of bail to the participant petitioner, so and so, so and so. This is also whose satisfaction?
It will be, my lord, Chief Judicial Magistrate Nalbari, my lord.
Nalbari.
Lord, Chief Judicial.
CGM number.
Much of it. We have stated in the application, if CCTV footage is seen in total, my lord, then the whole, how it happened, it will also come into light. my lord. Otherwise, nobody
But
will
you,
go.
you should not hit a police officer or whatever.
That is true.
And undoubtedly, I
Yes,
also
yes,
admit that the police has
Parent.
no such authority to
Yes, sir.
ask you to come to the police
Yes,
station and to inquire about the regarding the violation and all.
They were called.
That is not there.
Yes, yes. But it
Obviously,
should
it's not
yes,
there.
yes.
But the whatever the
Yes,
police
yes.
officer called,
My
maybe for amicable settlement also, maybe. Yes.
Because of the unnecessary intervention of police and civil.
Yes. Much obliged, highly obliged.
Item 29 and 30.
My lord, case diary was called for in last date, and since last 13 occasions, my lord, updated CD is not.
I don't know whether police
29
or
and
not.
30.
29 and 30.
It is pending, my lord, since a long time. It is more than a year, my lord.
So let us first inquiry whether it is received or not.
29 and 30, my lord, earlier CD was updated CD, man, CD
You are now required the up to date.
up to date.
That is not
That-
received.
Yes, ma'am. Earlier, the statement of the petitioner was not there, ma'am.
Oh, acha, acha, it was on
6/6/25.
no 26 only.
Yes, ma'am.
It was returned back.
Returned by my lord. Updated city was called for, my lord. And both the petitioners, my lord, appeared before the IO and recorded their statements, my lord, and they are duly cooperating in the
So it
investigation.
is not a case that the CD was not, it was received, but updated one was called for again.
Yes, 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 ma'am.
Yes, Botakur when it can be done.
Considering the, my lord, yes, I will get the report, my lord.
You are Mr.
S. Ahmed, my lord, on behalf of HR Chaudhary.
Hard Mr. Reader 2930 same order. Hard Mr. SS Rahman Ahmed, SS Ahmed appearing on behalf of Mr. H.R. Chaudhary. Also heard Mr. P. Watakur, the line additional PP appearing on behalf of said respondent. It is submitted by Mr. Watakur that on the earlier occasion the CD was received, but it was returned for updation and till date. But today the CDIO could not furnish the updated case diary. Post Mr. Ahmed submitted in this regard the diary was called for, case diary was called for on several occasions, and hence I may be directed to furnish the same on or before the next date of listing. Next para, considering this submission made by Learned Counsel for both sides, reminder may be issued with a direction to the police to furnish the updated case diary on or before the next date of listing. When it can be listed, Kotak. Give a long date on
2/9, man. 2/9.
List on 2/9, 2025 till then, the interim be extended. Okay.
Item 31.
Yes, your lordship.
Yes.
Lordship, 482 application, lordship, case diary was called.
39 petitioner is in interim, my lord. Here also case diary not received, ma'am.
You have not received the case diary.
Yes.
The sheet was filed against FIR name accused number 1 and 2, lordship.
No, I don't know. Against you also, charge sheet has filed.
I will get the report. Instruction. The lordship may allow sometime. He is already in interim. my lord. In that time, my lord, I will get the instruction regarding.
He want to submit that as per the FIR name accused number 1 and 2 has already been charge sheeted.
Yes, lordship.
And against you, no charge sheet is there.
Yes, lordship.
But we have to inquire the matter. If it is there the position, then
lordship.
definitely.
Yes.
If that is the position, then definitely
Both of
will.
them are enlarged on bail, lordship, because name FIR name accused number
No,
1
we are
and
not
2.
connection with those petitioners.
Yes, lordship.
I mean the accused persons.
Yes,
And
yes,
you are
lordship.
saying that Against your petitioner, no FIR has been, charge sheet is submitted.
Yes, yes, Lordship.
And that has to be seen, has to
Yes.
be looked into.
I will get the instruction.
In the meantime, you are calling for the case diary or no need, no required? Case diary also be called for.
Yes, your lordship may call for a case diary, during that time I will also get the
Inquiry, make an
instruction.
inquiry. You are MS?
A Das, Lordship.
Heard MS Adas, the learned counsel for the petitioner, also heard Mr. P. Waterpool, the learned additional PP appearing on behalf of state respondent. Full stop, expired, submitted by Mr. Waterpool, that is CD not received. CD not received, full stop. In that context, MS Das submitted that as per her instructions, the case has already been charged against the accused number 1 and 2. 1 and 2, and not against the present petitioner. Full stop. Let the updated case diary be called for, and the learned additional PP will also make an inquiry as to whether the case is also charged against the present petitioner or not. In list the matter accordingly when it can be listed.
19th of August.
19.8, till then interim be extended.
But nice.
Happy to. Please, your lordship. I am on interim, my lord. I have recorded the statement before the index of.
Madam, we have received the case there, madam. And after interim, he has appeared and statement recorded, madam. But regarding his involvement, madam, some matters are against him, madam. Personally, page 1 to statement, madam. Clear, madam. Two incidents are there, madam. In the earlier incident at 7 PM, madam. That incident, and at 11:30 another incident.
This is long time family dispute, my lord.
He is Yusuf. So now the present case is under which offense? One is for due to some this
Burning of house.
burning, one is burning and the other one is earlier one is this damaging shop house and all, abandoning, yes.
At 7, madam, 7 PM.
That is.
And later in the night, that incident happened, madam, that is.
So now this present case is under which sections now?
What does it?
In both the sections.
Madam.
329. This informant family has asked in 2018 they have killed my father-in-law.
This is long time family dispute was going on, my lord.
And another statement I have taken, madam.
I have a next FIR also, my lord.
329, suppose a house trespass and all.
My lord.
What is 324?
324 is mischief, my lord.
Mischief.
Yes, my lord.
Mischief.
And 326 is setting house on fire, my lord. That is not the
326
dwelling house also, my lord.
Dwelling house.
Not
G
dwelling
means, huh?
Not dwelling house, my lord.
G means not dwelling house.
No, it is showing dwelling house, but actually it was not dwelling house, my lord.
But it's shown as a dwelling house. only.
Yes, yes. Section has been added, my lord, but it was a house made of hay and all, my lord. Some cow thief is involved here, my lord. It should. They are habitual offenders, both the parties, my lord, but on 2018, my lord, my father-in-law has been killed by this family person, my lord.
So he was granted the interim on 18/2. 18/2.
Madam.
Yeah, obviously, there are some incrimination.
My lord.
Now, what do you suggest that is there requirement any for further custody, for not further custody interrogation is required or not? That
My
is
lord, yeah, regarding custody, my lord, but from the materials, my lord, available in the case day, my lord, some materials are there against him also, my lord. And also suspension is there, my lord, as it was in 7, it was some incident happened, my lord. And at 11:30, my lord, when none of the person is in the house, my lord, all of them went to some party and as per statement, my lord, burn the houses, my lord. That in this section, my lord, statement of the my lord.
What the police report says?
My lord, police IO statement is IO notice there, my lord, in the last portion, my lord.
And where is his own statement? Have you,
Well,
is the statement of the accused?
Accused, my lord, I have checked, my lord, only 2-3 lines, my lord. He has denied, my lord. And some
But
severe
no separate note of the IO that there may be some reasons for his custodial interrogation. It's not there.
Yeah, my lord. But some materials are seized by the police and along with photographs, my lord. That's in that all of them burned out, my lord.
Yes, everything is.
I was called by Saurabh Ali.
Hmm?
I was called by Saurabh Ali. Saurabh Ali is my friend. I was called by Saurabh Ali. I am Yusuf.
So he accompanied Sorabali and just committed the offense.
No, I know. Actually, it was the family dispute.
While giving the interim, there is no mention at all why
Madam.
interim was there.
And Lotime, even if Lotime called for upgradation, if there is some investigation.
No, the investigation is already there. The witnesses are also there.
My lord.
Now, there's no separate note from the IO also that for those reasons his custodial interrogation will
My
be
that-
required.
that-
That is also
I
not
have
there.
not.
And he was granted with interim in the case of such nature of case. I don't know. There was an order, obviously.
My
We'll go by the conduct only. What else? Will we do? Yeah, I see. We are on item number
32.
Heard Mr. D. Bora, the learned counsel for the petitioner. And also heard Mr. P. Sharma, the learned additional BP appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. CD receipt, where's receipt? It is submitted by Mr. Bora. The present date, the learned counsel for the petitioner that after obtaining the order of interim pre-arrest bail on 18/2/2025, the petitioner appeared before the IO, cooperated in the investigation, and also and his statement is also recorded by the IO. The petitioner is further ready and willing to cooperate the IO in further investigation of this case if he is granted with the privilege of bail. Next one, Mr. Sharma, the learned additional BP submitted in this regard that it is a fact that the petitioner had appeared before the IO and cooperated in investigation, but the CD reveals sufficient incriminating materials against the present petitioner, showing his involvement in the alleged offense. Mr. Sharma accordingly submitted that this custodial interrogation may be necessary for the interest of the investigation. Next para, considering the submission made by learned counsel for both sides, I have also perused the case record and it is seen that there are some materials collected by the IO against the present petitioner. But in the same time, it is also seen that the petitioner is cooperating the IO in the investigation of this case. And his statement is also recorded accordingly. There's no separate note on, there's no separate note is also given by the IO requiring his custodial interrogation in the present case. Next para, considering the entire circumstances of this case vis-a-vis the conduct of the accused petitioner, I find that custodial interrogation may not be necessary in this case. In view of this, the order of interim pre-arrest bail granted to the present petitioner on 18/2/2025 is hereby made absolute with same terms and conditions. Is post of recording.
Obliged, ma'am.
Six.
Disposed as
Yes. Yeah, after the city was called for my lord, we have not received name.
well. 36 besides.
My lord, after the city was called for my lord, we have not received the case date with the my lord, after the city my lord. Yeah, I will also paid for another debt my lord.
Paid for another day.
Fine.
Updated CD not received. Simple put updated CD not received, issue reminder directing the IO to furnish the updated case diary on or before the next date of listing. And list accordingly when it can be listed.
20 months. 20.
20.
August.
20 August. Interim be extended till next date of listing. Okay, your interim will be extended till next.
Interim, their interim can be continued.
Yes.
Not on lordship, sir.
Is it any difference?
Because two orders are there, your lordship. In all the three, they're all allowed interim. Lordship may verify you, lordship, in the order. 29/5 order is there, first order. And subsequently, there is another order, your lordship. And all three are already, your lordship, on
Right.
protection. And so far the information derived to your lordship, they did also appear, your lordship. But as permission, they were sent back actually. That's why lordship IO has taken time. your lordship.
Yes, you are rightly pointed out. 1 and 2 were not granted. Only 3. Jahana Rashi is allowed to call. Petition number 3 was only on entry.
Only on. 29/5, my lord. Order, my lord.
Yes, 29. Not 29/5, 19/5.
19/5.
No, initially 19/5, my lord. It
Then
was interim granted to petitioner number 3.
19/5 order, interim was granted to petitioner number 3.
My lord.
And again 29.
29/5.
Yes, your lordship.
Another order.
My lord.
Another order is there. So all three are your lordship.
Oh, then another order by 29/5, 1 and 2.
My lord.
Acha. Okay, now all three are in.
All three, Your Worship.
Okay, interim be continued, 3 years. still.
Yes, yes. Thirty-seven is also possible. Arranging order to.
It is article of
Sarsit submitted, ma'am.
charge sheet submitted.
Ma'am.
Are you on interim earlier?
Earlier interviews there, Your Worship.
Yes, CS number.
Madam, CS number 64 of 2025, dated 30/30/6/25.
Same order group had Mr. A. Devan, the learned counsel for the petition. And also had Mr. B. Sharma, the learned additional BP appearing on behalf of state respondent. The case was fixed for today for case diary, but it is submitted by Mr. Sharma. That case has already been charge sheeted by CS number 64 of 2025, dated 30/06/2020. They were on interim, we interim be extended 3 years. Oh. 15 days extemporary. So as you were on interim, we are extending your interim till 15 days. Within 15 days for regular bill application, you appear before the trial.
That will be subject to you. On filing the regular.
Yes. As per law. As per law only it will come.
37 to interim.
Disposed of.
Nice.
38 also you are appearing, I think.
Okay.
What is the position of 38?
38 is also for the information derived to Your Lordship. This is also it is filed Your Lordship. And accordingly from the trial I have been directed to appear Your Lordship. Already one date already elapsed Your Lordship. So that day Your Lordship, I couldn't appear because the pendency of this anticipated bail application Your Lordship. And accordingly Your Lordship 28 again fixed Your Lordship. So I am willing to appear Your Lordship. And
Today we have no any information matter regarding Sarsit matter. CD also not received today.
I have the copy of summon also subsequently I got Your Lordship.
So you can provide us if you have the number. If you have the number or CS number, you can provide us.
I don't have the CS number, Your Lordship, because the petitioner is directed to appear on the earlier date, Your Lordship. So that day, Your Lordship, we took time through advocate filing Kalatnama, Your Lordship. Accused didn't appear, Your Lordship, because
So
of.
now what do you want to? We don't have any instructions now.
Lordship.
CD is also not received and we don't have any instruction regarding the submission of the charge sheet. But you have the instruction that CS
I
has
have the
already been
instruction.
submitted.
So
If you
Lordship,
can provide us the number of charge sheet, then we can dispose of the matter. That's what I'm saying.
my submission.
Or otherwise you can withdraw this one.
Lordship, my submission would be, Your Lordship, since I have the definite information, Your Lordship, I want to withdraw, Your Lordship. I'll file a regular bail application out there, Your Lordship. So on filing the regular bail application, Your Lordship, my.
Whatever now you just want to withdraw this
Withdraw
one.
my.
Yes, Your Lordship. Okay. So an observation, Your Lordship, because I have the definite information, Your Lordship.
Heard Mr. A. Devan. Sorry. The learned counsel for the petitioner and also heard Mr. B. Sharma, the learned additional PP, appearing on behalf of state respondent. CD not received. Was true. However, it is submitted by Mr. Devan that as per the instructions of his client, case has already been charge sheeted and the petitioners have also received the summon. And accordingly they filed their petitions through their engaged counsel. In view of this, it is accordingly it is submitted by Mr. Devan that the present, how many petitioners? 2.
Lordship, against one, Your Lordship, as per information, Your Lordship, final report is given, Your Lordship.
Whatever maybe.
No, whatever may be, we are not going to detail everything now here now.
Two petitions.
Two petitioners are there.
2 petitions. Accordingly, it is submitted as per instructions of his, submitted that the petitioners will appear before the learned trial court below and will file a regular bail application to that regard. And accordingly, he submitted that the present petition, as per instructions, the present petition is intended to be withdrawn from this list. Accordingly, considering the submission made by learned counsel for both sides, and in view of the filing of the charges, the prayer of the petitioner is allowed, and the matter is accordingly disposed of on withdrawal. Okay.
Lordship, on filing the application. Your
No,
Lordship.
that we cannot say. This is on
Right.
filing. How can we say? You're going to withdraw this one.
Because
Your submission I have recorded. That you are intended to file the regular bail application. That has been recorded.
But it's not that you Lordship, that after filing of the charge sheet, Your Lordship, even then you Lordship can direct this.
No, you're going to withdraw this one. That's what we don't have any instructions. He is saying that CD, we have not received the CD. And apart from that, we don't have any instruction regarding the filing of the charge sheet. That's what we are asking you. We could not provide us this charge sheet. But I have submitted that as per instructions. Charge sheet has already been submitted. That is already there. That may help you also. We don't know.
Lordship, just, if you allow me, Your Lordship, just one submission, Your Lordship. Because 307 is there, Your Lordship, attempt to murder, Your Lordship. So if I appear, Your Lordship, and
We are not in a position to say anything, to advise anything. Anyway, next.
Team 39.
Yes.
Herein we are on interim. And Lordship, we had appeared and our statement was recorded. Now, as per our information, final report has been submitted in this.
My lord, here we have no any information, my lord. Today CD also not received, my lord. They are in jail, my lord.
You have the information, that final report.
That is our instruction, my lord, but it would be better if they confirm it.
Okay, then we'll make a, we'll ask the, CD, no, you can ask the final, if the final, he is saying the final report is there.
About this, the final report, they are not CD one. My lord. Pick Monday, my lord.
No, not Monday.
My lord. No, jadi FR dia nanti no. Aku sedih orang.
Or rather we can record your submission. If final report is there, there is no, cannot be any case of for apprehension of arrest and all. If final report.
That
but-
is our oral instruction, Lordship. That is why.
Okay, heard Mr. S. D. Learned counsel for the petition. And also heard Mr. B. Sharma, Learned additional PP, appearing on behalf of state respondent. It is submitted by, CD not received. Poster. However, it is submitted by Mr. Day that as per instructions, final report has already been submitted against the petitioners. In view of this, the Learned additional PP is hereby asked to make an inquiry as to whether the final report has been submitted against the present petitioners and also call for the case date. When it can be listed there. The question of interim and all also does not arise if a final report is already there. Monday, you are saying Monday, maybe on Tuesday then? Tuesday came on 29/7.
29th.
And your interim will be extended then.
Till then.
Till next date.
Much obliged.
Item 40.
May it please, Your Lordship. It's an anticipated.
You are appearing here for the informant.
And the case that was called for, my lord. Yeah, my lord, several
What
persons.
nature of case?
My lord, CD we have received.
No, what nature of case?
My lord,
We well-
326, 30, earlier 326 and 307, that is there.
Oh, acha.
So possibly the injury report would be necessary. And only thing, my lord, here, my lord, is, my lord, around how many persons, my lord, 14, my lord, 14 persons are named in the FIR, my lord. And in the, if the lordship kindly see the FIR, my lord, it states that, my lord, somebody else informed the informant, my lord. Another person, my lord, namely, my lord, Rajikul. So there was a, my lord, he was assaulted, the informant's, my lord, cousin. His name is Izhar Ali, my lord. And but allegation is that, my lord, all 12 to 14% came out from a shop, and, my lord, he was assaulted with, my lord, it states, my lord, rod, dagger, tubewell, handle, my lord. And the hand of the, my lord, victim was, my lord, broken, my lord. And there was stabbed him in the head also. That is the allegation. And it is important, my lord, last line, in due time, a man named Rajikul called their firm and informed us, my lord. So the informant, Moinul Haq, my lord, he cannot be an eyewitness to the whole occurrence, my lord. It is apparent from the
No,
FIR.
we are not trying.
No, no, my lord, what I mean, my lord, if he has implicated us, my lord, for that only, my lord, for that purpose, because he was informed by, my lord, this man Rajikul, my lord.
Your
And-
petitioner name is Safikur.
No, my lord, all 14s are before,
All 14.
all 14, my lord, because 5 sons, my lord, father is there, their cousins, all relatives, all have been roped in, my lord, and the background is that, my lord, they were, because of this election, my lord, somebody, petitioner of 5 wife, my lord, she won the election, ward, my lord, in Panchayat, and from the informant side, they are one of the relative, she, my lord, lost. That is the background, my lord. That has nothing to do, but it is the background, my lord. But here, my lord, see, kindly see, my lord, that because the informant was not there. So Rajikul, one person named Rajikul called and informed him that these persons were being beaten up this road. So kindly see the, my lord, whether, my lord, who has implicated whom, my lord, that part only. And what is the injury report, my lord? Because here, case has been, kindly see, my lord, case has been registered under 109 of the BNS, that is now earlier 307, my lord. And 117 too, that is earlier 323, my lord.
325, I think. 117 was 325.
1172, my lord. Possibly it is 323, possibly, man. But 118 too, that is 326
320.
earlier 320. So now, my lord, what are the injuries sustained and who has inflicted those injuries, my lord? And whether, my lord, fatal injuries are there. And our case is that he was admitted not by the police, my lord. He went to a private hospital, my lord, and there he was treated for 2 days. That is our instruction. And possibly there may be fracture of hand, my lord, what our instruction, my lord. But who has inflicted those injuries? Because 1 to 5 are brothers, my lord, and their father also, before lordship, he is around 65 years. That is petition number 6, my lord. And our case is that 4 and 5 were there, my lord. In our application, we said 4 and 5 petitioner, those 2 petitioners, they were there. They went to open the shop. Then there's some altercation, and it was possibly public also came and beaten up, my lord. So kindly see that aspect and whether any independent witnesses have stated whose names, my lord.
Okay.
My lord, here we have received the case there, my lord. There are 2 eyewitnesses are there, my lord. There are 183 statements are there, my lord. And Lordship, here medical report also received, my lord. It is grievous, my lord. And Lordship, some photographs are there, my lord. Lordship, kindly here is the photographs, my lord. Firstly, my lord, photographs. my lord. Next page also, my lord. That is- In the early phase of the mallet city, there is the medical report. my lord.
He sustained injury on the
Minor.
back side of the head.
Vital part. yeah.
Now 1 injury, my lord, or several, my lord. Okay.
There are other injuries.
Body, my lord.
Yes, yes. Other injuries. Legs, hand, everywhere.
My lord, our case, may kindly see, my lord.
Anyway, yes.
Yes, some photographs.
They attacks the petitioners. Informants rather than.
Huh?
In occurrence of common intention, that the petitioners, my lord, currently that the petitioner informants rather than person serious injuries to the person, my lord. But ethics is just not by full sufficient for lordship, my lord. The privilege of
You are
the
objective.
treatment, it's my lord.
I know, may kindly see 14%, my lord. If 14% beat up 1%, my lord, what will happen to him, my lord? And possibly exaggerations are there, my lord. And even, my lord, if it is grievous injury, whether it is, my lord, it falls within the definition of, my lord, that what weapon of was used, my lord, because where used, because 118 to, my lord. That, my lord, that will come, my lord, when, my lord, that it is grievous hurt. And it was caused by instrument of shooting, stabbing, or cutting or instrument used as weapon like death. So those part, whether, my lord, what is the weapon?
109 will come, my lord. Attempt to murder.
No, he was there for 2 days in our, my lord, our instruction, my lord, in hospital, that too in a private hospital, and whether taken by the police or not. And how can, my lord, 14%, my lord, absolutely exaggeration, my lord. And, my lord, whether eyewitnesses narrated that all the 14% are beaten up, my lord. If 14% beat up 1%, my lord, kindly see the nature of injuries, my lord. And if on the head, my lord, who inflicted that, my lord, that injury, my lord?
These are the matter of trial, my lord.
No, it is a question of liberty of a person, my lord. 14%, they will be sent to jail because of a false allegation against him, my lord. That may be considered by your lordship, my lord. And village people, lordship knows, my lord. Exaggerations are there, and my lord. 14% father, son, all assaulted one man, my lord. Can you see, my lord? And the informant was not there. And if it is omnibus, that if somebody says that all have, that would be omnibus, my lord, that all have assaulted, my lord. Itu sana ini, under the email.
Some of them have arrested, no.
One has been arrested, no? One that is number 9, possibly, no? Number 900, Bilal Ali arrested, no? Possibly, no? Yes.
Initially, 2-3 attacked, then thereafter all they have come and jointly with common intention, they attacked the person and they severely injured. That is the allegation. Okay.
All may not be implicated, all, my lord, whether all.
There are implications for all. That's what I'm just checking.
I don't know.
They came in a group with armed with all these weapons and all, and they started assaulting. That is the case. Initially, 2 or 1 of them they given first blow, and then they all of them have come. That is the allegation that I don't.
All, my lord, all should go to jail. And it's, my lord, because father is 65 years, and my lord, our case, my lord, that now.
You cannot. Father is 65, maybe 65.
No, I'm
They
just-
took
my
the
lord,
active part also.
That is true. No.
That
Only
is-
on
that is the
technical.
history or instances are there.
That, my lord, whether by what
Okay,
weapon,
I have heard a lot of.
what weapon was used, my lord?
14. We are dealing with item number 40. 40. Heard Mr. A. Chaudhary, the learned counsel for the petition, and also heard Mr. B. Sharma, the learned additional PP for the state respondent. And you're Mr. A.U. S. Islam for the informant. Informant, full stop. This is an application under section so and so in connection with so and so. CD received. Appears received. It is submitted by Mr. Chaudhary that all the family members of all the family members of one Safir Rahman has been implicated in this case, and the FIR has been lost against 14 members of people from their family, full stop. There may be a case of, there may be an altercation between the parties due to the opening of a shop.
No, my lord,
Shop.
earlier rivalry because of the
Earlier.
election, my lord.
So earlier rivalry because of the election, but no such incident had happened as alleged in the FIR. That further he submitted that out of the 14 numbers of petitioner, 1 or 2 may involved in the alleged offense, but all the petitioners are not at all involved in the alleged offense. Further, it is submitted as per his instructions. The accused, the victim was discharged after 2 days from his medical treatment, and medical treatment, and his statement is also accordingly recorded by the IO. He further submitted that all the petitioners are ready and willing to cooperate the IO in further investigation of this case if they are granted with the privilege of bail, interim privilege of pre-arrest bail. Next paragraph, Mr. Sharma have submitted in this regard that there are sufficient incriminating materials against all the accused petitioners, and the witnesses as well as some of the victim also uttered the name of the all the petitioners in their statement made before the IO under section 183 IPC. Further, he submitted that as per the medical report also, the victim sustained previous injury on his head and other parts of the body. And there is an allegation that all the petitioners attempted to commit murder of the said victim. Mr. Sharma accordingly raised objection and submitted that it is not at all a fit case to extend the privilege of pre-arrest bail to the present petitioners. Next paragraph. Mr. Islam, the learned counsel appearing for the informant, also submitted that all the accused petitioners belong to same family, came in a group and with having common intention. They assaulted the victim with the intention to commit murder. However, somehow he survived but sustained grievous injury on his person. Mr. Islam accordingly raised objection and submitted that the prayer for pre-arrest bail may not be considered at this stage. Next paragraph, during the submission made by learned counsel for both sides, I have also perused the case diary, and it is seen that the IO has collected sufficient incriminating materials against all the accused petitioners, showing their involvement in the alleged offense. As per the materials in the CD, all the petitioners took active part in the committing the offense and assaulting the victim. In view of this, considering the nature and gravity of the offense and the involvement of the present petitioners, I do not find it a fit case to extend the privilege of bail, pre-arrest bail to the present petition. Accordingly, the same stands rejected. Your petition stands rejected.
Father also.
Father also.
Much obliged.
41, Lordship, the.
Oh,
AD as well-
41 was supposed to hear at 2, but we forgot.
It's all right, Lordship. It's all right.
Medical
I made
report you have not received.
Just a moment. Please let me make my submission. I was of the impression that perhaps it will reach before 2 o'clock. So we made a mention in the morning. Now here, Lordship, sufficient time has been given to the prosecution to provide the medical document, but they are not yet in a position to produce the same before Lordship. Now this gives an adverse inference to the prosecution case that if this medical document is produced before this honorable court, perhaps I may be allowed to go on bail. Why I'm saying so, Your Lordship, I'll take your Lordship to 116 of BNS. Here there's an allegation of grievous hurt. Now what makes out a grievous hurt? If Your Lordship may kindly look into 116. Lordship, grievous hurts is emasculation, permanent privation of the sight of the either eye, permanent privation of the hearing of either eye, privation of any member or joint, distraction or permanent imperations of the powers of any member or joint, permanent disfiguration of the head or face,
fracture or dislocation of a bone or teeth, any hurt which endangers life or which causes the sufferer to be during the space of 15 days in several bodily pain or unable to follow his ordinary pursuits. Now your lordship will kindly see that on the last occasion they have produced one prescription before lordship, and it says that he has only a stitch inside his mouth. That was there. The prescription was there, lordship.
Prescription was there in the.
Yes, yes, in the CD itself. And very interestingly, your lordship will also see that the version of the informant was this, that I sat on the chest and has hurt him. Now lordship will kindly see the FIR which is there in page number 17. May I, lordship? Most humbly and respectfully, I beg to state that on the night of 25/5/2025, dates are very important here, lordship. Around 12:30 AM, I was going to Bohagi Vidai ceremony of our village Bohari. Was planned beforehand. The two accused mentioned above mentioned me. Accused number 2 held me from behind. Accused number 1 with intention to kill me started beating me with sharp weapon, causing serious injuries to the various part of my body. Furthermore, they struck me with a sharp weapon near my left eye when accused number 1 and accused number 2 beat me with the intention to kill me. Accused number 3 and accused number 4 assisted them in the assault. Due to the beating of the accused number 1 and accused number 2, I became unconscious. Thinking I was dead, the two accused left the scene. This is what is in the FIR. There is nothing regarding sitting on my chest and assaulting me. Now, lordship will kindly come to page number 13, lordship. That is the format of the FIR. Lordship, kindly have a look into the occurrence of the offence as paragraph number 3. Your lordship will kindly find that the time period, that is 12 hours, and it lasted till the incident. Your lordship will kindly see
35 minutes.
5 minutes. 12:30 to 12:35. In 5 minutes, can I implicate those wounds as mentioned in the FIR, lordship? The story is otherwise. The story is this, that the informant came to assault us, as I have on the last occasion submitted, and it was the advantage of my height. Since I was having a slightly higher height, when the informant has struck me, I simply prevented myself, and he got hurt with his dao. But now the medical prescription says that it is also false. He has no injury towards his eyes. Lordship may kindly have a look. He was treated just for few minutes as an outdoor patient, and he was allowed to go. So he was released.
So
And
where
then
from you're saying that 5 minutes?
there was no hurt in the eye as
No, no,
treated by
where
him.
from you're saying?
From the
that
prescription.
CD.
From the prescription, lordship.
Prescription when? The CD available?
CD available.
Acha.
On the last date, CD was available. And my colleague read out the CD and prescription that was available. Today, I don't know, lordship. Today, whether it is available or not, CD is available.
City is available.
CD may kindly be produced before lordship. It is video. Because I am not an interim also, lordship. And I am apprehending that I may be arrested at any moment of time.
How many
As
petitions?
per the statement of the victim, stitches inside his mouth, lordship.
Yes,
Statement of
that's what I'm
victim,
saying.
Parish lordship.
That's
Lordship,
what I'm saying. I remember on the last
Without
occasion.
injury report, lordship, it will be difficult, lordship.
No, it is a simple hurt. It doesn't fall under any of the parameters of 116, lordship. Absolutely a simple hurt. Question of causing murder as contemplated under 118 or 106 doesn't arise at all. 106 also I will read it out, lordship. What is there in 106? (109). I'm sorry, lordship. It is an attempt to murder. Whoever does any act with such intention or knowledge and under such circumstance that if he by that act caused death, this is important. Whether a stitch inside my mouth will cause me a death, lordship may kindly look into it. He would be guilty of murder, shall be punished with imprisonment of either description for a term which may extend to 10 years, and shall also be liable to fine, and if hurt is caused to any person by such act, the offender shall be liable to either imprisonment for life or to such punishment as hereinbefore mentioned. So I had read out 116 lordship. Here there is no emasculation, there is no privation of any part, there is no disfiguration, and neither the victim was inside the hospital for a period of 15 days. There is no fracture, there is no dislocation of a bone or tooth. Permanent disfiguration is of the head or the face is also not there.
But he sustained some injuries on his eye, I think. Eye injuries are there somewhere.
That is with his own dao. Now, Lordship will kindly see,
Without injury.
if I have implicated heart with the dao, that should have been recovered from my house. My house is at Bohari itself. For the purpose of some job, I am in Guwahati. But my parents are there in the house. Nothing has been recovered till date. And if my friend want to place the injury
Lordship,
report,
kindly
then
fix
my
it on
entry may
Monday,
kindly be
Lordship.
considered.
Monday, Lordship.
They have failed 3 occasions.
Lordship, this time I will personally call.
No, then let my entry be considered till Monday, Lordship. Let me go and depose before the IO. My statement may also be recorded, Lordship.
Heard Ms. Bhattacharjee, the learned counsel for the petition, and also heard MS Anders, the learned additional PP, appearing on behalf of state respondent. Next paragraph, it is submitted by MS Das that the medical report is not received, though the city was retained by them. Retained in the office of the public prosecutor. In that context, Mr. Bhattacharjee submitted that the last three occasions, the prosecution has failed to produce the medical report, and some prescriptions and the medical report which are available in the case diary also shows that no grievous injury was sustained by the victim at the time of the victim, and there may be some minor injuries sustained by him, which is also out of his own, he was inflicted.
Yes, Lordship. Out of his own weapon.
Out of his own weapon when he tried to hit the petitioner. Accordingly, it is submitted by Mr. Bhattacharjee that till the receipt of the proper medical report or the updated case diary, the petitioners may be allowed to remain on interim protection and may be allowed to remain on interim protection till the receipt of the medical report and updated case diary. Considering this submission made by learned counsel for the petitioner, or it is provided that both the petitioners will be on interim pre-arrest bail till receipt of the case diary, till receipt of the proper medical report and updated case diary.
Lordship, CD to be sent back.
Yes. Accordingly, again, thank you. CD be returned back, directing the IO to furnish the case diary, updated case diary along with the statement of the present petitioners, if recorded. The CD also should be accompanied and with the proper medical report of the victim. List accordingly 29(8) will be proper.
No. 29.
29(8).
Yes.
You'll be under interim protection.
I'm deplorable.
I get 42.
Last polling also indicate.
42, my lord.
Yes, what is 42?
CD was called for, my lord. May I read the FIR, my lord?
CD is received.
CD, my lord. May I read the FIR, my lord? It is an allegation for, my lord, fraudulent online transaction, my lord. I am not the FIR name accused, my lord. May I read, my lord?
Page number?
Page number 10, my lord.
10.
With reference to the subject cited above, I have the honor to state that as per the letter received from the office of the Superintendent of Police, Dorong, Assam, by memo number such and such, and on perusal of the enclosed document, it has been revealed that huge amount of transaction had occurred in the account number such and such, which is in the name of Farhad Ansari, the accused number 1 in the FIR, my lord, in account number so and so, which is in the name of Rajiv Ahmed from various other accounts. Besides the JMIS portal, 2 numbers of complaints of online fraud against the said accounts have been received from the Union Territories of the states of New Delhi and Maharashtra, Also, on the basis of the information received from Cyber Cell SP Office Durham, preliminary investigation has already been conducted by the Dhula PDS GD numbers 33 dated 25/5/2025, and below noted accused were apprehended, and on interrogation they confess about the commission of offense since almost 1 year. From the above facts and circumstances, it is found that below noted accused persons are criminally conspiring, committing financial fraud, inflicting heavy financial losses to the citizen. Now and accordingly, FIR registered, my lord. But I am not the FINM accused, my lord. I am a BSc student studying in my lord in a reputed college, my lord. BSc second semester, my lord. Now, my lord, police is my lord behind me, my lord. I don't know, my lord, why, my lord, because the FIR itself is questionable, my lord. Because Lordship will find at page 10, the CID has they have received a letter on 26/5/2025, and accordingly, FIR was registered. Your Lordship will find at page 8, it was registered under IPC, my lord. I may be wrong, my lord. After, my lord, 1/7/2024, the IPC was scrapped, my lord. I don't know, my lord, why IPC was page 8, my lord. And the FIR itself is, my lord, questionable, my lord. They cannot, my lord, prosecute me in a FIR registered under IPC, my lord, after 1/7/2024, my lord.
Yes.
Yes, my lord. Case diary received, my lord. Otherwise, there are sufficient materials again. My lord, what these accused person have done, my lord? My lord, these are, my lord, initially police arrested one Farhad Ansari and one Razib Ahmed and Abu Salam, my lord. Thereafter, my lord, these accused persons, my lord, on the basis of the some information through joint management information system, my lord. This is a web-based portal for, my lord, joint, my lord, my lord, this is, my lord, whereby, my lord, all those, my lord, coordination between various states regarding any cyber crimes, my lord. And from this portal, my lord, information.
What is the portal, name of the portal?
JMIS portal, my lord, JMIS, Joint Management Information System, in brackets, Saman, my lord. Is a web-based portal, my lord. Now, my lord, what these accused persons has done, my lord, they open, my lord, mule accounts. What are these mule accounts, my lord? These mule accounts are, my lord, often controlled by the third party, my lord. Although, my lord, account holder is someone other, my lord, these are controlled by someone other. And through these mule accounts, all these illegal transactions, my lord, of the cyber offenses, my lord, all transactions were made. Those may be, my lord, for terrorist funding, for money laundering, and for many other, my lord, financial, my lord, offenses, my lord. And, my lord, sometimes, my lord, it happened. This is also called as, my lord, layering transactions. That means, my lord, in this through these mule accounts, my lord, source and destination is also sometimes find it difficult to ascertain, my lord. And by using all those methods, these accused persons are involved in committing all these, my lord, cyber offenses. And now, my lord, today also your lordship has, my lord, grant interim protection for a, my lord, limited period to one anticipatory bail, my lord, today morning. My lord, what happened, my lord, in many cases, my lord, many persons from, my lord, within the state of Assam getting all these notices from various other states, my lord, that you are, my lord, required for investigation purpose regarding a cyber offense, because, my lord, epicenter of all these cyber offenses now in these days, my lord, in some parts of the, my lord, Morigaon within the state of Assam, Borpeta, my lord, in Biswanath. So, my lord, now Assam is a epicenter for commission of all these cyber offenses, my lord. For that reason, my lord, all these persons, so, my lord, transit bail is also, my lord, increasing day by day in our High Court also. Because of that, my lord, cyber offense from various cyber cells, my lord, notices were issued. My lord,
These are submission, my lord, all are academic, my lord.
Yes,
Whether, my lord, any allegation
I am
against
not
me,
going
it
to
is,
acad- I
it
am
is the
just
main
pointing
process,
out-
my lord. This is the academic purpose.
Maybe, but, my lord, I am just pointing out
We are
how
both
these
wrong,
cyber
my lord.
crimes are,
Academic
my lord,
purpose is not there.
having all this, my lord, because the epicenter is state of Assam. It is my duty to point out your lordship, and later on I will point out, my lord, the involvement of the present accused. Your lordship may kindly peruse the statement of how these accused persons are involved, my lord. What happened, my lord? They collected various, my lord, documents, Aadhaar card, PAN card, of the, my lord, various, my lord, innocent persons, my lord, from the, and they are not, I am not saying that those are innocent persons, but because, my lord, those, my lord, bank accounts were allowed to be used by the third party or by getting, my lord, money, my lord. Thereafter, those accounts were operated by all these, my lord, cybercrime, my lord, offenders, and those accounts were used for various transactions for various cybercrime offenses, my lord. And those transactions were used in, for various, my lord, committing offenses in some of the accounts were also used, my lord, in terrorist activities also, financing, my lord, through online transactions, my lord. And not only terror, money laundering and other financial, my lord, offenses also, these accounts are used. And your lordship may kindly peruse the statement of the accused, how they are involved in committing these offenses, my lord. And cyber offenses are, my lord, particularly in the state of
Your
Assam.
petitioner's name is?
Sanidul, my lord.
I'm not the FIR name.
No, whatever, your
Sanidul.
petitioner name.
Sanidul, my
Sanidul.
lord. His name is also there, my lord. Although, my lord, in the FIR, his name is not there. He is an associate of Farhad Ansari and Rajiv Ahmed.
On the basis of the statement of the co-accused, my lord, I cannot be prosecuted, my lord, that to be a FIR registered under.
This is an anticipatory, my lord. Investigation is still going on.
I will not cooperate with the investigation. I am the student, my lord. But I will cooperate with fully cooperate, will cooperate, my lord.
The other one is also student.
That
The
I
other
don't.
person is also student. Once Farhad, he is also a student. You are all students, right? Maybe
Yes.
press students also.
Those mole accounts are used to facilitate transactions, my lord, for money laundering, terrorist financing. My lord, police has also seized one fingerprint machine.
Fingerprint machine is
And,
also.
and name of one Shahjahan is also there in the state. He is a CSP operator. So with the help of those CSP operators and using that, my lord, fingerprint machines, they instantly open, my lord, bank accounts, my lord. And thereafter opening those accounts, my lord, they are involved in committing those accounts were provided to various other persons, my lord, of the outside the state of Assam also. My lord.
My humble submission before lordship, my lord. Whether, my lord, my involvement is there in the.
Yes, yes, your involvement is, that's what I'm saying.
My lord.
Your involvement is there. You were also the person who was used to open the mule account and all, and then committed these things.
This is the one part, my lord.
Obviously, this you are connected with that offense.
My lord.
You are connected. Your name is there.
As per my lord, their version, my lord.
Hey, their person, my person, we are not on that. We are on the
Anticipated
preliminary stage of.
The other part is, my lord,
That is now investigating. The matter is now still under investigation.
May I submit one thing, my lord? Whether my lord, police can investigate under this FIR, my lord. That real
Whatever,
logic
that
has to
will-
be
it will
considered,
come later on.
my lord.
It will come later on. It will be the last one. It will last for over. It will dictation what's on material to last for very long. We are on 42 now.
42, my lord.
Hard Mr. T.K. Bhuyan.
Lordship is going to reject, my lord.
We passed you now, passing the order only.
Fix the matter on next week, my lord. I will on law point, my lord.
How? We have listened the order, don't make such kind of submission. We are not going to reject. Reject, allow, it will become. Let the
May I
decision
pray
be
for some
made.
time, my lord, to argue
Hard
on law,
Mr.
law point, my lord.
Hard Mr. We are not, if we could have submitted these all things. We have spent only around 25 minutes for you.
Right.
That is not the case. Heard Mr. T.K. Bhuyan, the learned counsel for the petitioner, and also heard Mr. P. Potaku, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. CD receipt, where is received? It is submitted by Mr. Bhuyan that the present accused petitioner is a student of BSc second sem, and he is no way connected in the alleged offense. The petitioner is not aware as to why the police is searching for the present petitioner without his any kind of involvement in the alleged offense. Mr. Bhuyan also pointed out, raised the point that the present FIR was lodged on 26/5/2025, but surprisingly the case is registered under IPC sections, though the BNS is implemented since 1/7/2024. Further, he submitted that the present accused petitioner is is no way connected in the alleged offense, and he even does not know as to why the police is searching for him. However, if as a petitioner is ready and willing to cooperate the IO in further investigation of this case, if he is granted with some interim protection post. Next paragraph. Or privilege of pre-arrest. Next paragraph, Mr. Potaku, the learned additional PP submitted in this regard that that from the materials available in the case diary, it is seen that the present accused petitioner also involved in the alleged offense, and he, along with some other co-accused persons, were had obtained the Aadhaar card, PAN card of some of the persons, and thus they initially opens a mule account, MULE, mule account, and where from all the monetary transactions were where when all the money transactions were there, and even they used to transact money with some you're saying with whom the transaction was also there?
As per those mule accounts are used for various illegal financial
Used
offense,
for mule
for
accounts
terrorist
were used for
financing, for money laundering, those are
various
offenses.
financial transactions, including money laundering and financing some organizations and other
Financial
other financial
offenses, crimes.
financial offenses. First. Thus, this present accused petitioners, along with the co-accused persons, are criminally conspiring and committing financial fraud, inflicting heavy financial losses to the citizen of India, citizen India for their wrongful gain. First. They wrongful gain. Accordingly, he's further submitted that the present petitioners is also involved in the alleged offense in opening the mule accounts for such monetary transactions. His mobile number is also found using those in his mobile number is also available. No, like, not activate. Sorry. Accordingly, Mr. Bhattakur submitted that the custodial interrogation of the present accused petitioner will be very much essential for the interest of the investigation, and the case is still under investigation at this stage. Still under investigation. Mr. Bhattakur accordingly raised vehement objection in allowing the present petitioner to go on bail to provide to extended the privilege of free arrest bail at this stage. First, considering the submission of the learned counsel for both sides, I have also perused the case record and case record as well as the materials as well as the case diary. From the materials available in the case diary, it is seen that the modus of operandi of the modus of operandi of the accused persons in the connection with this case was to get some was to initially to collect the Aadhaar card, PAN card, etc. from some of the persons, and then using the fingerprint machines, etc., with the help of other co-accused persons, they used to create some accounts, mule accounts, and with creating those mule accounts, they were involved in committing financial fraud, and they thus heavy financial loss to the nation. It is also seen that from the statement of some of the witnesses as well as accused, this fraud, this crime is been committed since last more than 1 year, and thereby misappropriated a huge amount of money through this financial fraud. It is also seen that the petitioner is also involved in the alleged offense, and he is also one of the person who took active part in creating those mule accounts for the financial transactions. The issue raised by the learned counsel for the petitioner, Mr. Bhuya, in regards to the registering a case under the IPC sections in spite of this the implementation of the BNS on 1/7/2024. It is seen that the the matter should have been instituted or registered in a proper section of law, which has not been done by the IO, and accordingly by the IO. And the learned Uday Salvo accordingly the investigating officer is hereby may make an prayer before the learned trial court below for alteration of sections and to register the sections in the proper sections of law. However, considering this aspect only, I do not find it a fit case to extend the privilege of privilege of pre-arrest bail to the present petitioners, considering the gravity of the gravity of the offense, In view of this, in view of this, the present petition filed by the petitioner seeking pre-arrest bail is hereby stands rejected. Your petition stands rejected. There will be some corrections in the order.
My lord.
And those findings. Okay. Oh. Could proceed to 42. Rest matters will be adjourned.
57, my lord.
All the matters will be adjourned and tried now.